Welcome. I'd like to call the meeting to order. Today is September 26, 2018, to the Nevada Irrigation District Board meeting. Please join me in the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. The first item on the order will be special orders, so there will be no action taken, and at this time I'd like to defer to Director Wilcox for the introduction.
Well, I have the distinct pleasure this morning to introduce Vicki Whitney, who is my old boss and mentor and a true Yoda of water rights in California. I have to admit, I had the great fortune of being plucked from the environmental assessment unit at the board by Vicki to work in Bay Delta issues. I later succeeded her in that position, and I learned from her the fine art of poaching staff. So I poached other staff, and we carried on. Vicki's husband is here in the audience, Ken Landau. He's raising his hand, but he didn't look, so he's back there. Ken was the former executive officer of the Central Valley Regional Water Quality Control Board, and one of the prime targets of staff poaching was Ken's organization. So you can just imagine the dinner table conversations that took place at the Landau-Whitney household, where you have the deputy director of the State Water Resources Control Board and the executive officer of the Regional Water Quality Control Board sharing the table. Vicki's a wonderful boss and a true expert in the subject in which she is presenting today, and I hope you had a chance to review her curriculum vitae. She is, rather than go through it, I will just say that Vicki is like the Forrest Gump of water rights in California. She's been everywhere and involved in everything, and there is nobody better at this. So Vicki, have at it. This is water rights in California. The idea is to present an overview of water rights with some specific attention paid to kind of local issues that are of significance to us. So Vicki, thank you so much for being here.
Thank you. What Nick didn't mention is that my husband tried to get his staff back after I poached them by offering one guy my car, my brand new Audi, and but the guy didn't leave, and he succeeded me as the deputy director in water rights. And then the other thing Nick didn't mention is our daughter works for the State Water Board now after she got her master's degree, and her job was performance management tracking, and so our daughter tracked the performance of both her parents and gave us thumbs up when we met our performance goals and thumbs down when we didn't meet our performance goals. And now she's working on Bay Delta stuff off and on. So I am the former deputy director of the State Water Board. I worked in water rights for 23 years, and I was the deputy director for 7, and then I was the deputy director of the water quality program for another 6 years, where I worked on things like recycled water and desalination and other issues that interact with water supply issues, but indirectly, because I was working on it from the water quality end, like what do you do with all the brine from desal, stuff like that. Anyway, so my presentation this morning is on water rights. And I'm going to talk a little bit about the general water right authorities, some general policies from the state, surface water rights. I will very briefly talk about groundwater rights. I have a lot of slides. I've given this presentation before. It was a week-long class when I did it in China, so it's a lot of information crammed into a fairly short period of time. So some of them I'm just going to skim over. Special situations, some of which I understand affect NID, and then questions, and hopefully I'll get answers for you to the questions, and if not, I can certainly tell you who to talk to. Oops. Okay. How come it's not going forward here? I thought it was on. There it goes. Okay, so the Water Board gets its authority from the Constitution of the State of California, specifically Article 10, Section 2, which says that all water use in California has to be reasonable and it can't be wasteful. California became a state in 1850. In 1851, it adopted English common law as the law of the land, and that's all it did in terms of water for 60 years. So for 60 years, all water right disputes were resolved by the courts. In 1913, the governor appointed a commission to look at water issues, and the commission recommended that there be an administrative mechanism for assigning and tracking and monitoring water use in the state of California, just for ease, because all these water cases were taking up too much court time. So the state legislature eventually codified a lot of what had been going on through case law into the water code, and that water code has been modified and added on to since then, and now directs the water rights program in California. And then the State Water Board adopts regulations that implement some of the statutes that the legislature has adopted. And then, as I mentioned, there's years and years and years worth of case law that direct the board's actions. So what does the State Board do? For those who don't know, we determine who diverts and uses water and under what conditions that water can be diverted and used. Process petitions to change water rights that it issues, and it enforces against a number of illegal activities, including unauthorized diversions, permit violations, interference with prior rights, waste and unreasonable use of water, public trust violations. Public trust is traditionally considered to be in-stream uses like fisheries, recreation, and navigation. It may assist the court with determinations of water rights for those types of rights over which it doesn't have permitting authority. It helps the courts when the court refers water right matters if they need assistance on water right issues. Somebody from the Water Board will provide assistance to courts. And it prosecutes groundwater adjudications to protect water quality. The last one, it has the authority to do that, but we've never actually done that in the state of California. So there are some general policies in the Water Code that guide the water rights program. The first is actually associated with federal law, and that is that water rights is a states' rights issue. Each state has its own authority to allocate water, and most of the western states do it similarly. The eastern states don't really do it at all, and that's because in the eastern states it rains a lot, and so they have more supply relative to their demand than the western states do. But anybody who's west of about the 100th meridian has essentially a similar program, but there are differences. So if you came from a different state and you know water rights in that state, don't assume it's the same in California, because it's probably not. And California is different in a couple of key ways in regard to how it treats water. Water belongs to the people of the state. That's the people collectively, not the people individually, which gets to the next one, which is that a water right is what's called a usufructuary right. A usufructuary right means that you have the opportunity to use a resource and to make money from that resource and to do other things associated with that resource, but you don't actually own the resource. And probably the best analogy that I can come up with is leasing a commercial property for business. You have the right to use the property, to generate revenues from your use of that property, but you're not the owner of the property. So the state owns the water in this case. Beneficial use of water shall be maximized. Water shall be conserved, and water use must be reasonable. You can't use water for unreasonable purposes, and you're not supposed to waste it. So what triggers the need for a water right? In California, there are two elements. One is taking water under control, and the second one is putting it to beneficial uses. You don't typically need a water right for in-stream uses like fisheries, navigation, and recreation because you're not taking the water under control. It's just flowing down the course of the river. You don't need a water right for flood control because you're not putting that water to beneficial use. Instead, what you're doing is avoiding a nuisance. So you're trying to keep the water off the property, which has some interesting implications in California because there are some flood control reservoirs that for all intents and purposes look like any other reservoir, water supply reservoirs, and they don't have water rights associated with them because they were built as flood control reservoirs. And usually the way you can tell the difference is the Army Corps of Engineers operates the flood control reservoirs and for the federal government, and the Bureau of Reclamation operates the water supply reservoirs. Now, some flood control reservoirs do have water rights on them, but the federal government doesn't hold those water rights. They work cooperatively with local agencies, and they make the local agencies go through the permitting function to get the water right for the project. And then they jointly operate it. The Army Corps will operate it in the winter, and the local agency gets whatever water happens to be left in storage after it's been operated for flood control, and they operate it during the summer, and then in the fall it goes back to the Corps of Engineers. So issues of concern in any water right is how the right is acquired. California is often talked about as having a dual system of water rights. In actuality, we have more than two different kinds, and I'm going to quickly run through what those are. A lot of people get really hung up on the State Water Board's permitting authority because the State Board has fairly limited permitting authority over water rights, actually. But it has broader authority over other types of water rights where it works jointly with the courts to enforce conditions like the waste and unreasonable use condition, which the Water Board can enforce against any water user regardless of the basis of their right, even if it's not a water right permit that the board has issued. The other thing is that since 1914, when the Water Commission Act was adopted, if you need a permit or if you need a new water right, the only way to get that new water right is to get a permit from the State Water Board. There is no other way to get a new water right in California since then, and the courts have confirmed that over and over and over again. Also, what I'm going to be talking about is how water rights are lost, whether they can be lost. And then lastly, what do you do if there's not enough water to meet the demand on the demands on a stream? So what is water right priority? This is a word that I'm going to use over and over again. Basically, it's the order in which the State Water Board curtails diversions if there's not enough water. So you get a priority relative to every other water user on the same system that you're taking water from. Think of it as lining everybody up like in a soup line. And the first person gets their soup, and the second person gets their soup, and the third person gets their soup based on this priority. And at some point, the soup runs out, and the soup Nazi, that would be the State Water Board, says no soup for you, and everybody else gets curtailed. Where that pot of soup empties, or when that pot of soup empties relative to the users, depends on the water year, obviously, because if it's a wet year, there might be soup for everybody. And if it's a really dry year, there might be soup for 2 people. So now I'm going to talk about surface water rights, which I understand are the types of water rights NID has predominantly, right? In fact, maybe exclusively. Yeah, and you guys have lots of permits. I remember that. I haven't worked in water rights for 10 years, but I do have recollection of some things. So the types of surface water rights, and even though they're called surface water rights, they also apply to this category of water called a subterranean stream. And if you think about it, it's like an underground river. The only problem is that underground rivers only really occur in certain types of geology, and for the most part that geology doesn't exist in California. So the legislature adopted this law talking about subterranean streams, and they didn't define it, and it didn't really exist from a scientific perspective, but it exists from a legal perspective. And it applies to that water. And I'll talk about how you distinguish the water later in the discussion. So this is the kind of, these are the kinds of water rights, surface water rights that exist in California. I have adjudicated in quotes because all that means is that some court has acted on one of the prior types of water rights. And the only one that the Water Board has permitting authority over is this one, Post 14 rights. But I'll quickly talk about the others because it is important when you start talking about how you're going to curtail things. Pueblo rights were the first kinds of water rights that existed in the state of California. They exist under Mexican and Spanish law. And when the United States took possession of the lands that they took from Mexico in 1849, the United States agreed to recognize existing Mexican rights under the Treaty of Guadalupe Hidalgo. This is kind of a history lesson of the state of California. And one of those rights that they agreed to recognize was these existing Mexican or Spanish rights. They only applied to Spanish municipal bodies. So the Spanish had in California religious organizations, those were the missions, military organizations, those were the presidios, and then they had pueblos. You can only have a pueblo right if you were a pueblo under Mexican or Spanish government. And you had to have your status as a pueblo confirmed in the 1800s. There are only 6 places in the United States, in California, that meet this criteria. None of them are you. They're all on the coast. And only 2 of these rights have been confirmed, one in San Diego and one in LA. But it's a great right to have because it is the highest priority right in the state. If you have that right, you get the right to the entire flow of the stream, surface water, tributary groundwater within the historic pueblo, the stream that flowed through the historic pueblo, but you can use the water for the current boundaries of the municipality. So LA has pueblo rights to the Los Angeles River, and they can use it anywhere in the city of LA. And we never have water right disputes in LA because basically they trump everybody else. Nobody else can use any water. They have claims on the entire quantity of the stream. The quantity of water you can use under the right is determined by the present municipal needs of the city. And you never lose this right. So if you want to have one, this is the best kind to have. There are these things called federal reserved rights, and the legal conception of this is that when the federal government granted lands to the state, they reserved for federal use water necessary to carry out the purposes of federal reservations that were set up. So usually those are forest lands or tribal reservations. These are pretty good rights too. Water rights can only be used for the primary purpose of the reservation though. So like on a forest, it can only be used for growing trees. It can't be used for campgrounds because that's not the primary purpose of a forestry reservation. Secondary purposes have to get water right permits from the state. The priority is the date the reservation was created. Often that's in the mid to late 1800s. It includes surface and groundwater, and it's the amount of water that's sufficient to serve the needs of whatever the reservation is. For tribal reservations and for forestry reservations, that's generally considered practical irrigable acreage. And when you think about forest reservations in California, national forests, and you're talking about practical irrigable acreage, that can be a massive amount of land. So that could be a huge right in terms of the volume of water that's needed, although the federal government has not historically claimed that much water. But the interesting thing is they probably could. So could the tribes at any point in time. And that would really mess up some of the existing uses that are occurring because they'd bump them down in priority. So riparian rights are privately held, and those are the rights that most people, one of the 2 types of rights that most people think about when they're talking about the dual system of water rights in California because they're relatively common. To have a riparian right, you don't have to get a permit from the State Water Board. You don't have to continuously use water. You can start using water anytime you feel like it. The rights are correlative, so if there's not enough water available to serve the riparians are curtailed proportionally. according to their needs. So it's share and share alike is the phrase that's often used for this system. Disputes between riparians get resolved in the courts, not by the water board unless the courts ask them to intervene, ask the water board to intervene. And one thing about riparian rights is that in about 1980-something, there was legislation that was passed that allowed riparian right owners to assign the water that they had historically been diverting under their right for in-stream purposes for fishery protection. Those are called 1707 transfers, and they happen every so often. And they do that through the water board's processes. Okay, so there are a bunch of rules about who gets to use water under riparian rights. You can only use water under riparian right if your property abuts the source stream. The water that you're using has to be the natural flow. It can't be augmented by imports of water from other places or by releasing water from upstream reservoirs. It's got to be the water that would be flowing past your property in the absence of any activity. Water may not be imported from another stream. I just said that. You can't store water under riparian right. The place of use has to be in the watershed of the stream source. And so what happens is these kind of rights account for fairly small amounts of water because of all these restrictions. So here's an example, and I'm going to get to the picture. So the right attaches that the priority of the right depends on when the land was patented. That's when it became available for private ownership. The right is lost when a parcel is physically separated from the source, usually by subdividing the property. The right is limited to the smallest legal tract in the chain of title, and once lost, it is never restored. It is gone forever. California actually tried to eliminate these kinds of rights in the 1920s, but was told by the courts that they couldn't do that, which is really interesting because almost every other Western state did successfully eliminate the riparian right claims that had previously existed in their state prior to them adopting an administrative permitting system. Oklahoma recently was told, you thought you exterminated the rights, but you didn't really. So California and Oklahoma are the only two Western states that even recognize these kind of rights. Nobody else does. But here's an example. So you have a stream. You have a guy who owns property A and a guy who owns property B. Those guys can both divert water. They don't have to have a permit. If there's not enough water for them, they share what water supply is available based on their needs. But now say there's a mountain range on parcel B's property, so that the water in the land in this upper corner is in a different watershed. That water flows down to some other stream. This property B guy can't take water out of the stream to use on this part of his parcel, even though it's one parcel, because it's not in the same watershed. So now the property A guy decides he's going to subdivide his property. Unless he makes statements in the deed to indicate that he is transferring the riparian rights with the property that he's transferring, this parcel now loses its riparian rights, never to be seen again. So he could still use riparian water on this part of his property, but the new owner of this parcel can't use it under riparian right anymore. And if he wanted to use it, he would have to get a permit from the state water board. And that's what happened predominantly in California. So now we come to appropriative rights. You need an appropriative right for diversion of water on non-riparian parcels or for diversion of what's called foreign water. Foreign water is water that's been imported from another watershed. You need an appropriative right to store water on any parcel unless you're just storing water temporarily, usually considered less than 30 days. And that's an artifact of how people used to irrigate, where they would flood irrigate. They'd temporarily dam a river to get the water level up high enough that they could gravity feed it through their system of canals. And then they'd pull the flashboards on the dam and the water would continue down the stream after they were done irrigating. So it's not really a storage of water from a season of deficiency or from a season of plenty to a season of deficiency. It's just an operating mechanism. Appropriative rights can be sold. The right is quantified and it cannot be increased. So you have to think about it at the time that you're seeking one of these rights, how much water you're ultimately going to use, and that's how much water you should apply for, because If it turns out you need more water, you'll have to get another water right. Your second water right, being acquired at a later time, will have a junior priority and will not be as valuable as your first water right. So a lot of forethought goes into this. You can forfeit your water right by inaction. Forfeiting means you give it up, you lose your water right. It's a use it or lose it rule. Abandoning means you did it intentionally. Forfeiting means you just didn't use it for some reason and you weren't intending to abandon your water right, but the State Water Board can come in and revoke your water right for lack of use or for lack of diligence if it's an application that you filed for a project you're pursuing. That happened on Auburn Dam. So the Bureau of Reclamation had water right permits for Auburn Dam. They started to build the project in the 1970s. They discovered that it was sitting on top of a fault line. A lot of extra work needed to go on. There were a lot of costs associated with that work. Congress did not allocate the funds to do that work. That went on for, 40 years. And basically they were cold storaging the right is what it's called, keeping it speculatively. And that's a no-no under state water law. You cannot speculate in water rights. It's a use it or lose it system, and so the State Water Board revoked the permits. What that does ultimately is make that water that had been allocated to the Bureau of Reclamation at that location available for anybody else who might want to come in and build the project in the future. The priority of an appropriative right is the date that the appropriation commenced. It's called first in time, first in right. Usually, if it's a permit that's issued by the State Water Board, it's the date that you filed the permit. If it's a appropriative right that was initiated before the State Water Board or its predecessors were in existence before 1914, it's the date that you first took action to try to establish the right. So basically, in 1914, when the legislature adopted the Water Conservation Act, they grandfathered in existing uses, including those riparian rights that I talked about, and any appropriative rights that were going on. In California, most of those appropriative rights were held by either hydropower companies or miners. So those are the early users of water in California, and also irrigators. If you're talking about areas like the San Joaquin Valley, where irrigation first occurred in around 1870. So the state grandfathered in those rights, but the courts have applied limitations on those grandfathered rights. So the right must have been initiated before December 19, 1914. The right does not require a permit from the State Water Board. You have to report how much water you're using, but it's just a reporting mechanism. The quantity associated with the right is limited to the amount of water that was used in 1914, except there are some exceptions to this, one of which is called the doctrine of, I forget what it's called. Where's the attorney? Relating back or something like that. Is that it? And so the priority of the date of the right relates back to the date that the water right claimant first took action to establish the right. An example of that is the city of San Francisco's Hetch Hetchy system. The O'Shaughnessy Dam, which forms the Hetch Hetchy project, was not constructed until 1923, I believe. But the courts determined, after going through the record, that San Francisco started efforts to establish that water right immediately after the 1906 earthquake, when the city of San Francisco burnt down, partly because of a lack of water supply. And so the water rights are pre-14 rights that the city of San Francisco holds for that reservoir, even though they didn't build it until 1923, based on the efforts that they initiated in 1907, looking for a water supply and the plans that they developed. Yes?
Why is 1914? Is it a random selection of the year and now it's important, or why was it important?
1914 is the date of the Water Commission Act. So you will remember that I said that the governor set up a water commission to look at how to administer water supplies in the state more efficiently. It's the date that the permitting requirement came into effect in law. And so anything before December 19th, 1914 is the grandfathered right, and things after that are water rights that you have to get through the State Water Board. The Water Commission Act was actually adopted in 1913 by the legislature, but it was controversial at the time, and there was a referendum, so there were enough signatures that were gathered to put it on the ballot. It went to a vote of the people, and it barely passed in 1914, and it went into effect the following day. So it's not a random date. It's a date that's associated with history, but it is the cutoff
Legislative.
for when you could appropriate water without a permit versus when you had to get a permit to appropriate it.
Thank you.
Great question. Let's see. And then there's another couple of, whoops, they told me this was touchy. There's another couple of exceptions. Again, you have to use water diligently because there's those use it or lose it restrictions, and you have to put it to continuous, reasonable, beneficial use. So if you stop using it for a period of time, you can use the right. Or if you don't follow through with your plans to develop the project, you can forfeit the right as well. And then there's this legal concept called the doctrine of progressive development, which relates to that. So essentially the idea is that if you have a pre-14 right and you plan to use, I don't know, 200,000 acre-feet a year of water, for example, but you're a municipality like the city of San Francisco, the state didn't want to encourage just willy-nilly waste of water because that's a prohibition or development. So you get a fairly long time to actually develop use under your right. And as long as you are progressively developing use, you get a fairly long period of time to develop the right up to the maximum amount. There were two methods of getting a pre-14 right. One is the common law method. Under that method, you basically just used water. You took water, you put it to beneficial use, whammo, you have just developed a appropriative water right. There were some disputes that resulted from that methodology. So in 1872, the legislature adopted what's called the Civil Code procedure. It was under the Civil Code, not under the Water Code, because the Water Code didn't exist. And under the Civil Code procedure, you did what miners did. You went out to where you were going to take water on the stream, you posted a notice, you put in your notice what you're going to use the water for, how much water you were going to use, and you filed a copy of that notice with your county recorder. And that action is what initiated the right that you might have under a pre-14 right. There are some issues with that too, because people would, they weren't using the best science at that period of time, and they would claim like 18 times as much water as existed in the stream under their right. But now if people want to prove up that they have a valid pre-14 claim, one of the things that they do is they'll go to the county recorder to look to see whether any notice was filed of these water rights. And that's evidence that at least there was an attempt to develop a water right, as opposed to the common law practice where you have to look at things like, gee, was there a pipe? Gee, was the pipe constructed out of materials that were used before 1914? Did they use square horseshoe nails? Other sort of circumstantial type of evidence to prove you're right. Let's see. So, after December 19th, 1914, the only way you can get a water right in the state of California is to get a permit from the State Water Board. Wasn't always the State Water Board. It was originally the Department of Water Resources. Well, it was originally the Department of Public Works, and then the Department of Water Resources, and then eventually the State Water Board. And you do that by filing an application with the board. And when an application is filed, the board will issue a public notice of the application, or if it's for a lot of water, require the applicant to publish the notice in a newspaper, and people get to object to the proposed application. Once those objections are resolved, if the board finds that there's water available for appropriation under the application, the board will issue a permit. And the permit is kind of like a driver's permit. So a driver's permit allows you to learn how to drive. You get to drive with a driving permit under certain conditions. You have to have an adult in the car who has a driver's license, etc. Water rights is kind of the same way. The permit allows you to construct and develop your project. Once you have used all the water you think you're going to use under the permit, or the development schedule that is a permit condition in your permit expires, you get a license, and the license confirms that you have put water to beneficial use, which is a requirement of actually getting the water right in California. And the license contains a quantity of water that you're allowed to use and some other things. And that quantity might be as much as the permit allows, but most likely it's less because people tend to apply for more water than they actually put to use for a variety of reasons. One is the requirement that if you use more water than you're permitted for, you got to get a new permit, and they don't want to do that. NID has 23 permits, is that right? It's around that. Oh, down to 14.
A bunch of licenses, though.
Yeah.
Oh, and a bunch of licenses.
58 licenses.
58 licenses. So some of them are multiple licenses on the same project. Some of them are independent projects. It just depends. The water right is issued for the appropriation of unappropriated water, which is defined in the water code. Basically, it's any water that's not being used by pre-14 guys or under riparian claim. Post-14 rights apply to surface water and those subterranean streams I was talking about. And you cannot, the state board will not accept a water on stream systems that have been declared by the state board to be fully appropriated. The state board, when it's going through reviewing these water rights applications, at some point will get to a point where it says, sorry, no more soup for you. Nobody else can get a permit. And that's very constricting for development in a lot of states. Some states, the entire state is fully appropriated. I think Utah has allocated all of the water. So if you want to build a new project in Utah, you got to go buy somebody else's project out and then ask the state to transfer their water rights for use on your property. You cannot get a new permit. California has actually got a lot of water relative to a lot of the other western states. And then the other thing is that the State Water Board has continuing authority. If you want to make changes to your permit, you have to go back to the State Board and request permission to make those changes if those changes have the potential to impact any other water user. That was the situation for a long time. It used to be that people thought that licenses were sacrosanct. Once you got a license, the water was pretty much yours to do whatever you wanted to do with, as long as you complied with the conditions under the water right. In the 1980s, the water board was sued. The water board lost the suit. It involved Mono Lake in the eastern Sierras. Some of you guys might be familiar with that. And the court said that the water board had a continuing authority to review and essentially manage water right licenses to protect public trust. Those are those in-stream uses, if it was feasible to do so. And so that gave the water board authority to go back in and review all these long-term existing licensed water rights and amend them. And that's one of the bases for the Bay Delta actions that are going on now. The state water board is going back and looking at these water rights and saying, okay, how much water do we actually need for fish? You know, in 1927 or 1960, when we issued these permits, we thought it was X amount. Well, now we think that it's X times Y amount. And so we're going to look and see whether it's feasible to restrict water diversions under these long existing rights to protect public trust uses. Water right permits specify the purpose of use, the point of diversion, that's where you take the water from the stream, and the place that you can use the water, the amount of water that you can use, which is defined both as a rate and as a season. So you can use 10 gallons per minute that you can divert from March 1st to September 30th. The priority is usually associated with the application number, since the applications are filed in chronological order and the numbers are assigned chronologically. The permits may not be assigned based on the chronology of the application, but the application is. But not always. There are exceptions, and I'll talk about them in a little bit. The permit contains a project completion schedule. It used to be that you had to start building your project. I forget what it is, but it was a really short period of time, within like 3 months of the time you got the permit. Well, you know, I'm sure the NID board can appreciate that it takes you more than 3 months to get all the other permits you need and get your construction equipment out there. So that start construction date isn't as fixed as it used to be, but you still have to diligently start construction of your project. It's also got a project completion schedule when you're done with construction, and then a date by which you have to put water to beneficial use, and that's the date that triggers the review of the permit to see if it's going to go to license, or potentially the water right owner can request that that permit project completion schedule be extended, but that requires a whole nother proceeding before the State Water Board, and subjects the project to re-review. So people tend not to like to do that. Whoops. And then the last one is the other conditions that the board puts in depending on the specific project to protect downstream prior water right holders, the public interest, the public trust, and the environment. And a lot of those conditions are mitigation measures that are identified in CEQA or NEPA documents these days. There are various types of permits that the State Water Board issues. The primary one is just a regular permit license process. As I said, people can object to the initial issuance of the permit. They can also object to any changes that the permittee wants to make. They do that by filing what's called a protest. If the protests are not resolved, the Water Board can either deny the permit or approve the permit with conditions. The process by which you do that is specified in the Water Code. For little projects, it's done by staff after they conduct a field investigation. For major projects, it's done by the board, and the board would hold a hearing on the protests, and the protestants at that point have an obligation to prove up their protest to demonstrate that the issues that they're raising are valid issues. If they don't, the board can dismiss them. The board dismisses protests, has dismissed protests in the past fairly regularly. If the board finds that the concerns are valid, they will, if they're going to approve the permit, they will put conditions in to protect either the environment or protect downstream water users. Then there's a bunch of special category permits. They're only for small users that meet certain criteria, and they're listed right here. You can get one for livestock watering, you can get one for small domestic use, and you can get one for small irrigation projects if you're on the north coast streams. Cannabis cultivation is occurring now under these small irrigation projects. And basically, the reason that this was adopted is because there are massive numbers of small users in the state of California. There is no de minimis exemption for having to get a water right permit. Even if you're only using, a very small amount of water, you still have to get a permit. And administratively, these huge numbers of small people were overwhelming the ability of the state to issue the permits, and so the legislature wanted to get these guys legal and provide a mechanism for legally diverting the water rights, so they adopted a special process just for these little guys. Okay, so going through all that about how you get a permit, there are special situations that affect the priority of your water right. These are all in the Water Code. They're laid out. The first one is municipal preference. If you are applying for a water right permit for municipal use only, you can only get this for municipal water rights, you can ask the state board to give you a higher priority than other people who are applying for water from the same stream at the same time as you, even if they filed their applications first. So this essentially reverses the priority given the municipality preference. And that's because the legislature recognizes that drinking water for people is very important. And there are actually policies in the beginning part of the Water Code that says domestic use is the highest use of water, and this follows along with that. Yes?
Is that restricted to the watershed, the municipalities in
No.
said, so they can take water from LA can continue to do what they've always done?
Yeah, LA doesn't have water rights to the Delta. They have a contract with the Department of Water Resources to the Delta, and the Department of Water Resources contract is not just for municipal use. It's for municipal and irrigation and other uses because they deliver water for other purposes. So this doesn't apply to them. An example of where it does apply is on the McCollamy River. East Bay Municipal Water District, which serves water to Oakland, gets its water from the McCollamy River. They have 2 dams on the McCollamy River, and they did apply for municipal preference, and there were in-stream or in-basin users who had applications that were filed prior to East Bay Mud's application. North San Joaquin Water Conservation District in specific. And the Water Board gave the higher priority water right to East Bay Mud. They allowed the North San Joaquin Water Conservation District to use water in the intervening time until East Bay Mud perfects its water rights, maximizes how much it's going to use, but that's a temporary right. I'll talk about that, I think it's on the next slide. That's the example that comes to mind immediately. And that makes doing curtailments really complicated because you have sort of this general priority scheme, and then there are these things that reverse priorities, essentially. The next one is what are called state filings. In 1927, as a result of a drought, well, prior to that, actually, the state engineer had gone through and identified good locations in the state for building dams. And the legislature adopted water code sections that directed the state to file applications for those good locations for the amount of water that the state engineer thought was available. The state holds those applications, and really what they're doing is putting in a placeholder. So they're putting in a placeholder for future coordinated water development. The Department of Water Resources has permits that were issued on state-filed applications. These state filings were done at various points in time, but most of them were done in 1927. A bunch of them were done in around 1960. And the triggering event was the construction of the Central Valley Project for the 1927 permits, and the construction of the State Water Project, which is operated by DWR, in the 1960s. And so there were concerns by people in the area that the water originated that, oh my goodness, LA is going to divert all the water from our watershed and there will be no water for us for future growth. This was the legislature's response, was directing the state to file these state-filed applications, basically to set aside a block of water for the ultimate use of people in those areas of origin. And you can access that water by requesting that the state filing be assigned to you. I think I've got a slide on that later on. Or if your project is not consistent with all of those lists of things that were in my earlier slide about what goes into a water right permit, you can file an application that is not a state filing, but you can ask to be released from the priority of the state filing. It's kind of a weird phrase. But what that means is that when you are proving up that there is water available for appropriation under your permit, the State Water Board will not take into consideration that amount of water that was set aside in the state filing. So think of it as a pie.
So that reconciles the doctrine of progressive development? You're saying the state putting in these state, it seems inconsistent that on the one hand.
I'll get to
there's
that
this,
in my
okay.
next slide.
All right.
So the state, at the same time that it did these state filings, also adopted statutes, the first of several statutes that are referred to collectively as area of origin protections. I'm going to talk about the other kinds of water rights, and then I'll talk more about state filings and area of origin. So prescriptive rights is basically legalized theft. Think of it as squatters in terms of real estate. You're using somebody else's property, you use it for a long enough period of time, guess what? You can develop a right to it. If somebody builds something on your property, kick them off. To get a prescriptive right, your use has to be actual. It has to be open and notorious. That means that the property owner has every expectation of knowing about the fact that you're illegally using their property. It's got to be adverse to them, and it has to be under claim of right. When you're dealing with property law, this concept usually means that the person is paying taxes. The person who's prescribing the right is paying taxes on the property, for instance, or doing other things to act like they own the right themselves. Has to be continuous and uninterrupted for 5 years. But the kicker is, there was a lawsuit in the 1980s, and the court said you cannot prescript the state. So illegal users were illegally using water, saying, hey, I've been illegally using water for more than 5 years, and so I don't have to get a permit. But remember, one of the primary requirements is that since 1914, you can only get a permit from the state. I mean, you can only initiate a new right by getting a permit from the state. So what the court said is you can't prescript the state of California. You still have to get a permit from the state. So what happens if somebody's claiming a prescriptive right in actuality is they claim the prescriptive right, they file an application with the state, then the state will process their application, and if the legal owner protests that application, they can be stopped from moving forward with their protest based on the fact that they have this prescriptive right. But these are really only confirmed by the courts. I can't think of any situation where the state board has dismissed a protest based on a prescriptive right claim where the courts haven't previously confirmed that a prescriptive right exists. So that case law in 1980 kind of put a lot of restrictions on this whole prescriptive rights thing. But they do exist in California. Riparians can prescript other riparians. Remember I said there's share and share alike if there's not enough water. Hey, if you've been using all the water and some other riparian is being injured as a result of that, you could prescript a riparian. And the courts have confirmed one of those fairly recently, I believe. Yeah.
Where is that set priority?
Huh?
Where is priority set in that?
It's the priority of the right that you've prescripted.
When you file it, or when you say that you were open and notorious?
If you're a riparian prescripting another riparian, again, it creates more of an estoppel than anything else at this point, I think. I'm not a lawyer, but you have a lawyer, so I'm going to ask your lawyer. I'm an engineer.
So let's say you've got a 1920 permit that's prescripted. The prescripting party acquires a 1920 permit, essentially.
So it is when it started open and notorious?
No.
It's when the initial right was initiated.
Right. The prescription period could have been 1980 to 1984. And that doesn't mean that that's the new date of priority under the right. It still reverts back to the permit date.
Okay.
So you want to prescript against old rights before you prescript against
You
new
betcha.
rights. You wanna hurt the
Prescripto,
old-
Pueblo right.
You want to hurt the old guys.
Okay. And then I had a category I called adjudicated. That just means that the rights have been confirmed by a court. So for all of those rights that are not permits issued by the State Water Board, if you're relying on a diversion of water under that right, you're only relying on a claim of that right. It isn't until the court says, oh yeah, you have this right through some court process that you actually have one of those rights. Prior to that, it's just a claim. When the court does that, they will set forth the rights of the parties who have previously claimed the right in a judgment. They'll issue a decree. Often in areas that have a lot of these activities going on, the decree will be administered by a water master. He's the water cop. He works for the court. There's a whole bunch of these in northeastern California, like Modoc County. There's a whole bunch of these in LA. There's a few of them that are scattered around the rest of the state. And water masters can either be hired through the Department of Water Resources or they can be hired privately. So there's a couple of adjudicated streams in San Mateo County on the coast. They have private water masters. They just hire an engineering firm usually to administer the right. But the water master has a lot of power. Sometimes you read about, like on the Klamath River, where the water master, goes in and locks down diversions. So those guys up there, they all flood irrigate, right? So they have these canals that have floodgates, or they have flashboards on them on the stream. Water builds up, again goes down the canal. Or they have a flashboard with a hole in it that restricts the amount of water that can flow into the canal or flow into the pipe. The water master can go in and lock them down so that they can't divert water if there's no water available for them. So this is kind of the, I think when the legislature was setting up this whole system, their thought was that eventually all of these claimed grandfathered rights in the state would be adjudicated, and you'd end up with all these decrees, and you'd have this very orderly system. In other states, that is occurring to some extent. Montana is trying to adjudicate every stream in the state of Montana. Colorado did adjudicate every surface stream in the state of Colorado. California is like the Wild West of water, honestly. So we have all these various types of rights. We still recognize them. A lot of them are not quantified. But at some point, maybe we'll get there. And I'll tell you why we haven't done it in a minute. It's cost. There are two ways to do a water rights adjudication. In both cases, the board's role is an advisor to the court. So the board conducts an investigation and makes recommendations to the court. The court actually adopts the decree and is the final adjudicator. The process is not subject to CEQA, which, if you're the water rights staff person, is great because it makes your life much easier. But the reason is that it's not an administrative agency that's taking a discretionary action. It's the court. And courts aren't subject to CEQA. So if we were going to adjudicate the Central Valley, for instance, to solve the Delta crisis, that would be a court proceeding if you're going to do an adjudication, and there would be no CEQA document written for it. The reason that we don't do more of these in California is that the law allows for the reasonable costs of the adjudication to be allocated to the affected parties. So it used to be that the state water board would say, oh, we're only going to charge about 25% of our costs that we incurred in doing this adjudication to the parties, and we're going to write off the other 75% as training or whatever. It's in the public interest, a whole bunch of reasons. Well, when budgets got tighter in the 1970s, and now that the water board is fee supported rather than general fund, tax supported, the state water board's not willing to do that anymore. So the state water board has had people come to it and ask it to initiate adjudications, and when the water board tells the parties, well, yeah, we'll do it, but you guys might have, you guys are going to have to pay the cost of this. And then we do an estimate of the cost, and it's $5 million. Usually they go, forget it, and they walk away and they do their own thing. They sue each other. That happened on Poudre Creek in 1980, 1990. They were talking about doing an adjudication, and what happened instead was Sonoma County Water Agency just sued everybody who was using water on the stream. So they had this massive lawsuit, and it probably cost them $5 million anyway. You got to the same point. Except there is one difference between the way they did it and the system that's set up for coordinated stream system adjudications. I said there's two different types. One is a court reference. That's where I sue Nick on some water rights issue. It's complicated. The judge says, I don't know anything about water rights, because it goes to the Superior Court, and the judge says, I need help. He can refer the matter to the State Water Board, and the State Water Board will help him with findings of facts and make recommendations on the law. That's called a court reference. And then there's what's called statutory water code, or statutory adjudication, which is under a different section of the water code. That's where the intention is to determine comprehensively the rights of all claimants to water on a certain stream system or a certain stream reach. That's initiated by a petition to the water board. That's what could happen in the Delta. Somebody files a petition, says, hey, we want an adjudication. The water board will determine if it's in the public interest and whether it wants to proceed, and then it'll go through and proceed. It'll take this report to the court, Superior Court, and say, hi, we went through this proceeding and it took us 10 years, and now we want to have you confirm it. And then the court will hold a series of separate hearings to decide whether or not to do that. The last one of those statutory adjudications we did was San Gregorio Creek in San Mateo County, and I think there were 500 property owners and 350 water users, and it took about 15 years to do the adjudication. A court reference, unlike a statutory adjudication, applies only to the named parties. That was the first example I gave. I sue Nick. Anything the court says only pertains to us. It doesn't pertain to the rest of you, even if you happen to be diverting water on the
Scott
same
gets
stream.
off. Scot-free.
When you sue Nick, don't you have to stand in line?
To sue Nick?
Yeah.
Well, I don't know.
Oh, I hope so. See left and right, brother?
Again, I already talked about the statutory adjudication. I said there were a couple of differences. The big difference is this one applies to all water users. Another big one is that you can subordinate riparian rights. So remember how I said riparian rights are usually higher priority than appropriative rights? There are two exceptions to that. One is when the appropriative right was initiated before the land was patented, so the appropriative right predates the date that the riparian right applies. And the second one is when you've gone through a statutory adjudication. If you have somebody who has a dormant right, they have a water right because their land meets all the criteria, it's next to the stream, it's within the watershed, but they've never used water, they still have a riparian right, but it's an unexercised riparian right called a dormant right. And going through the statutory adjudication process, you can subordinate that right to all of the existing uses of water. And that's basically because the courts recognized that people spent money to construct water diversion systems or put in, you know, whatever they've put in. Say you build a factory and you're using water rights, water under your water right for the factory. That was an investment, and this is kind of in recognition of that. The other advantage is that you quantify riparian and pre-14 rights. Pre-14 rights are kind of quantified anyway because they're limited to the amount you used in 1914 or thought you were going to use in 1914. Riparian rights are totally unquantified. In the decree that the court issues, they'll essentially get what are permit conditions. You can use water that you take at this point of location, on this property, under this priority, and this is how much you can use, and this is when you can divert it. The disadvantage is that it's time consuming and expensive. The state of Oregon is doing an adjudication that they started in 1975. Other states are doing adjudications that they started about the same time. I already said that one in San Mateo County, you know, took a decade. These are long processes because they're complicated. They involve a lot of findings of fact, and they involve a lot of legal argument usually. And I think that's why they don't get done. I'm going to talk about groundwater rights really briefly because I don't think you guys have those for the most part. The kind of right that you, the system that you fall under depends on how your groundwater is classified. Remember I talked about those subterranean streams flowing through known and definite channels? If that's where you're getting the water from, you fall under surface water rights law even though you are diverting water from under the ground. I'll talk about that a little bit, and then I'm going to talk about groundwater adjudications, and then I'm just going to quickly mention the new Sustainable Groundwater Management Act, but not in any detail. So we have these subterranean streams flowing in known and definite channels. The water code says if you divert water from a subterranean stream flowing through a known and definite channel, you have to get a permit. If it's groundwater that is not a subterranean stream, it's referred to as percolating groundwater because the idea is that it percolates through the soil into this groundwater basin. Subterranean streams are treated just like surface water diversions. Percolating groundwater is under its own whole category of water rights, which is all case law. No statutes, no legislative action. The legislature, when it adopted the Water Commission Act in 1913, talked about adopting a permitting scheme for groundwater, and they said, oh, it's too complicated. So they didn't. And it's only gotten more complicated since then. So the seminal case law for subterranean streams is this case involving the city of Los Angeles. Remember I said Los Angeles has Pueblo rights. They own all the rights to the stream. Some guy was diverting groundwater, Mr. Pomeroy, adjacent to the stream, and LA wanted to shut him down. And so they said that water that that guy is diverting is part of this surface stream. And that case went to court. And the judge in that case, it was a jury trial, the judge in that case issued instructions to the jury. And in those jury instructions, he specified what the criteria were for determining whether it was a subterranean stream. And those criteria are what the state board used sort of off and on, because for a while they talked about interconnection between the groundwater and the surface water. And for a while they used these 4 criteria in that legal case. And in 1990, they started consistently using the criteria that were in that legal case after our lawyers did this huge legal review. So in 1990, the board used what's called the Garrapatta criteria, because it was out of a water rights action on Garrapatta Creek, which is down near San Luis Obispo. And the board set forth this 4-part test that was contained in the instructions to the jury in this 1899 legal case. There was very little case law in between those 2 years. So like 100 years, no case law, no legislation, nothing. And the board got sued subsequently for using this test. And the test is, for a subterranean stream, there has to be a subsurface channel. So you have to have relatively impermeable bed and banks. And where that occurs is where you have a river that's being cut through bedrock and then filled in with alluvium. Those rivers exist all over the state of California, mostly on the coast, but all over the state of California. The course of the channel must be known, or you have to be capable of inferring the course of the channel, and that's pretty easy to do in those kind of carved valleys. And you have to have groundwater flowing in the channel. That's it. There was a lot of controversy when the state board started using this, and we hired a bunch of technical experts and a bunch of legal experts to advise us. And all of the people who had been complaining that we were using this criteria, after we issued the report based on the recommendations of all these experts, liked the proposed new criteria less than they liked the criteria set forth in this 4-part test. And so nothing ever happened. The board is continuing to use this 4-part test. And interconnection is not part of the test. There's a recent court case, I'll talk about that very shortly, that kind of ties that idea back in. But legally, now there's an appellate decision, so it's precedential decision. Legally, this is the criteria that you use to determine whether or not you are diverting water from a subterranean stream. The problem is that it's not legally presumed to be a subterranean stream until somebody says it is. And the person who's claiming that it is a subterranean stream has to prove it. So in the meantime, you got all these guys sinking wells right next to streams. The sinking of those wells is drying up the streams potentially. They're claiming it's percolating groundwater. At some point, the state intervenes and says, no, we think it's a subterranean stream, and now you have all these existing users who've been using water potentially for years who are suddenly deemed illegal because they need a permit from the state. They don't have a permit from the state. That happened on the Carmel River. Nick worked on that hearing, and the board ultimately developed this list. It was Table 14,
Table
I think.
13.
Table 13, the Table 13 users, and gave those guys an opportunity to come in and file applications for the water that they had been using historically, and gave any permits issued on those applications that might be filed priority over the permits of the water district who was seeking a permit to build a dam on that river. So this can get, they did the same thing on the Russian River. Except it was based on some hydrologic reports that were done by the Army Corps of Engineers in 1949. So in 1949, the Corps of Engineers knew who all the users were. They didn't specify whether they were legal or not. A lot of them are not legal. But the board, in granting water rights to Sonoma County Water Agency, did the same thing, created sort of this table of pre-49 users and gave those guys an opportunity to come in and file a water right application, which, if a permit is issued, then has a higher priority than the permit issued to the water district.
Vicki, are you close to the end here, or?
Oh, I'm talking about state filings and area of origin protections, and then I'm done.
That's very important, so we should do that. Because we want to leave some time for audience questions.
I am not going to talk about this then. This is a new law that was adopted tells local agencies to go out and manage their own groundwater basins. It requires them to do that. And if they don't, the state will step in.
Right, and we are a Sigma agency.
Okay, so
Yeah, very
what
minor
happens
way.
if there's not enough water? You can have not enough water because of drought, for instance, due to climate change, because there's too many people taking water, or because there's an environmental collapse and the state has an obligation to protect fisheries under the public trust laws. Then you curtail people. You curtail them in reverse priority. So you cut people off in this order: post-14, pre-14s who post-date land patents, riparians, pre-14s who predate land patents. Federal reserved rights can fit in anywhere depending upon when the reservation was set up. And then the Pueblo guys get cut off last, and mostly they never do because their rights are so superior that usually if you cut off all these other guys, you'll provide enough water in the stream regardless. Then you have these exceptions. Municipal preference, we already talked about a little bit. I'll talk about it in the next slide. State filed water right applications, which Nick specifically asked me to address, and area of origin protections, which Nick specifically asked me to address. I already mentioned those in passing. Let's see. Your question, I don't remember. You had a question about municipal preference.
Well, your description of the table 13 or whatever sounds contrary to the municipal of the state.
Sonoma County, yeah.
Seems to, I was going back to the doctrine of progressive use when the state had put place markers in. but
Right.
Let them sit
Oh,
for
that's the-
60
yeah,
to
that's-
80 years, and that doesn't seem that fulfill the doctrine of, so,
That's
Couple of questions.
The,
I'm just
the
listening.
state water board has a lot of
a
discretion.
lot of discretion to being consistent, it sounds like.
Yes.
Okay.
So for these municipal preferences, the municipal user gets priority. Other people can use it for an interim period. The municipality can then go in and take over their water supply projects, but they have to pay them for the facilities that they've constructed. State filed water right applications have the priority of the date that they were filed by the state, usually 1927 or around the 1960s. While they're held by the state, this answers your question, there is no diligence requirements for them.
The state is exempt.
The
so
state
to
is
speak, of
exempt
course. Okay.
because no project is being developed. It's just a placeholder.
NID is not the state.
NID is not the state. So once a state filed water right application is assigned to you, or you are released from the priority thereof with your own application, you are subject to diligence requirements. You have to diligently pursue the water
Which is
right.
the doctrine of, okay.
Yes.
Huh.
State Water Board has to have a hearing to assign any portion of a state filing. Again, if you have a proposed project that's inconsistent with the conditions in the state filed application, you can file your own application and be released from priority. And again, think of it as a pie. So the state board says, hey, we have this pie for future users. They could be anywhere. And we're going to give you a piece of pie, give each one of you a piece of pie, but Nick's not going to eat his pie. So his permit gets revoked because he hasn't been diligent and he hasn't pursued his project.
He's got all these lawsuits stacked up.
Yeah, that's why he's busy. So his piece of pie goes back in the pie tin and is available for somebody else who wants to come along and ask for permission to have that piece of pie.
That's the doctrine.
That's the doctrine.
Thank you.
Okay, so all these protections, basically, in summary, reserve two areas where water originates, some undefined. Inchoate is the legal term, preferential right for future water needs. Inchoate means you have to do something to actually acquire the right, but it's set aside for you. They also allow export to other areas during the period before local needs develop. So the Central Valley Project and the State Water Project, which divert water to the San Joaquin Valley and coastal Southern California, respectively, have permits on state filed applications that allow both in-basin uses and export uses. Those exporters get to use the water until projects are developed in the area of origin. That means there's no water for them. So effectively, despite all of this water right priority law, statute, case law, it makes the exports of the CVP and the State Water Project of natural water last in line. So that list that I talked about how you curtail people, when Nick and I worked on Bay Delta stuff in 1995, that's exactly what we were doing, was going through in an environmental document, identifying whose rights would be curtailed. They got cut off first, regardless of their 1927 priority, regardless of anything else. If it was an export of natural water, they were the first people who got cut off. That does not mean that we cut them off for releases of previously stored water that they hold in their reservoirs. Water going into their reservoirs would be curtailed relative to the priority date of their application, 1927. But water that they release from their reservoirs and then redivert down in the delta was okay, as long as it was previously stored water. It was only if it was natural water that we cut them off first. And we got sued on that issue, and State Water Board won. Okay.
That gets into these refill criteria.
Pardon me?
That lends over to the refill criteria to
similar.
define what the water actually, which waters are which.
Yes.
Okay.
Some of the actions that we took under the D1641, the Bay Delta decision, actually did contain refill criteria, because some of the irrigation districts in the San Joaquin Basin, Merced Irrigation District, Tuolumne Irrigation District, were voluntarily meeting some of the objectives during a 30-day period between April 15th and, well, between April and May. And they were transferring water to in-stream uses for fish and wildlife, and people objected to that transfer, and we put conditions in our approval of that transfer so that they wouldn't adversely impact other water users. And when we talk about refill criteria, that's kind of what we're talking about. You know, you've got a, well, actually that's not refill, that's recharge. Never mind. Okay, so area of origin protections are this other body of statutes that the state board imposes as permit conditions on a case-by-case basis in permits that it issues. In theory, they resolve a threat that the board issued export permits for immediate use will harm potential future users in the protected watershed. The courts have found that among protected users, there is no priority of right. So if you are somebody who is getting water delivered to you under a contract that you have with the Bureau of Reclamation, the Bureau of Reclamation gets to set in their contracts the priority of their contract users. It's not associated with these area of origin protections because that is previously stored water. And those protections are not entitled to water from those subject to protection at a lower cost than any other customer. So the board can, the Bureau of Reclamation or the Department of Water Resources can set their own prices for the water that they deliver to contractors, whether they're in-basin or out-of-basin contractors. There are 4 area of origin statutes: County of Origin, Watershed Protection, Delta Protection, and the new Watershed Protection Act, which Craig Wilson, who was a former chief counsel for the Water Board, he wrote a paper. He referred to it as the protected area legislation. I referred to it as a new Watershed Protection Act because that's what it was introduced to me as when I started working for the board. But that was in 1984, and so it's not new anymore. I think that's why he changed the name. So under area of origin statutes, these date back to, it says 1927. I think they were actually adopted in 1931, but they related to the legislation providing for state filings that was adopted in 1927. Again, that's what the statute says. Release of priority or assignment of a state filing shall not deprive the county in which water originates of any water necessary for development in the county. As the county needs the water, it shall be withdrawn from outside areas and made available to the county of origin. That is based on an Attorney General opinion from the State Attorney General that was issued in 1955. Watershed Protection Statute is a little bit different. It applies specifically to the Central Valley Project and the State Water Project. that were constructed as units of the original Central Valley project that was conceived by the state engineer in the 1930s. The Central Valley project was supposed to be constructed by the state, and then the Depression happened. The state couldn't fund it, so the feds stepped in and funded it. That's why the feds operate a major water project in California. It was also, the state and federal water project were all supposed to be part of the same project originally. This one also says that it will not deprive the prior rights of all water needed for beneficial uses in the watershed, and prohibits state filings from being assigned if there will be impact to county of origin. So again, it makes the exports subordinate to the in-basin users. In effect, it makes the CVP and SWP exports last, related to direct diversion rights and diversions to storage within the basin. Then there's the Delta Protection Act, which was adopted in 1950s, not coincidentally, just before the state authorized the construction of the State Water Project, which delivers water to LA. It protects users in the Delta. It provides for salinity control in the Delta and adequate water supplies for Delta users in statute, not in actuality. It prevents diversions from Delta channels to which Delta water users are entitled, and it reiterates that CVP, SWP exports are subject to the prior needs of upstream areas of origin. These statutes, the last one, the new Watershed Protection Act was adopted in 1984, and basically it just kind of extends these watershed protection ideas to other areas outside the Central Valley. So specifically, the legislation names Central Valley, Mono Lake, Truckee, the Walker, and the Carson River systems, which state of California shares with Nevada, and the Russian River. I don't know how the Russian River got in there, probably good lobbying. Yeah, Randy Poole. And it allows in-basin users to obtain a higher priority right than the exporter, or to contract for water from the exporter. So, regarding Randy Poole, on the Russian River is kind of a miniature Central Valley project. You got imports of water from the Eel River at the top of the watershed. You got exports of water to Marin at the bottom of the watershed. You got a couple of reservoirs that are operated by Sonoma County Water Agency and the Corps of Engineers jointly. And so it was the same kind of thing, and I guess the legislature thought, hey, it worked in the Central Valley, we'll use it here too. But the Central Valley Project and the State Water Project have a unique obligation to work in the interests of the people of the state of California, because they are government-owned, they are state and federal government-owned projects. On the Russian River, it's a local water district. So it's a little bit different. So what this means, again, is that in times of shortage in the Central Valley, water diverted directly, natural and abandoned flows by the two big water projects under their water rights are curtailed first. Water diverted to storage in those project reservoirs, I spelled reservoirs wrong, during times of shortage is curtailed based on the priority of the water right for the reservoir. Water diverted by other permittees is curtailed based on the priority of the rights they hold. And the CVP SWP may continue to export water to the San Joaquin Basin and to LA that they stored previously in reservoirs despite all these curtailments. The board implements this through a water right permit condition called Term 91. The Central Valley Project and the State Water Project use natural channels. They use the Sacramento River and the Feather River to convey water from their reservoirs to their export pumps in the Delta. There are a lot of water users along the Sacramento River and the Feather River. And those water users look out and they go, hey, water's flowing past my property, there's water available for appropriation, and they took it. Some of those water users would file applications. The Bureau and the Department of Water Resources were filing protests. In order to deal comprehensively with these people, the water boards held a hearing in the early 1980s and issued a decision in 1982 that said, we are going to impose this water right condition in every permit over a certain amount that we issue on diversions of water within the Central Valley watershed. That condition is Term 91. For the little tiny guys, the water board just said, hey, no water for you in July or August. You don't get July and August in your season of diversion. So if you have a summertime use, you better find some other source of water, like groundwater pumping or something else. And the state board routinely curtails water diversions in the Central Valley based on Term 91. What they do is they send out a notice to people, hey, it looks like there's no water for you during this period of time, but this period of time this year, and we're telling you that we are probably going to curtail your water diversions. And that's so that growers can make planting decisions or other activities can go on. Then the State Water Board calculates how much water is being released from the CDP and SWP reservoirs to meet their delta obligations, water quality, and to meet their contract obligations to their south of delta users. So basically what their legal obligations are how much water is being released from the reservoir in excess of the amount needed to meet the project's water quality obligations in delta and south of delta contracts. And they take that block of water and they go, okay, this is how much water is being stolen from the system. They count in riparian uses and things too to some extent. And then they start curtailing people who have Term 91 in priority order until that amount zeroes out. So in 1 year, it may be, X amount of water. They'll start cutting people's water diversions off until the Bureau and Department are releasing no more water from storage than they need to release to meet their obligations. And the idea is that any additional water is water that's being basically stolen from the projects because it happens to be flowing past somebody's property. It's a big accounting thing. Nick and I and a couple of other people worked on that in the 1995 Bay Delta EIR, and there were lots of rules, and we had big spreadsheets, and it was all modeled. And we wanted to memorialize the methodology that we used because A, it got confirmed by the courts as being reasonable. B, we shopped it around and asked a whole bunch of people, do you see anything wrong with this from a legal perspective? And so we actually had this chart called the Map of Nick's Brain that we maintained, and it was a flow chart that talked exactly about how we did this. And I think the state board is doing essentially the same thing for its environmental review of delta actions that are going on now. There have been a couple of cases that involve area of origin protections since then. The most significant one was EID versus the State Water Board. EID is El Dorado Irrigation District. Sometimes they're known as El Dorado Water and Power, but they were EID when this came up. The board, they requested a state file. They requested assignment of a state filing, and the board issued a permit based on that request, and it imposed Term 91. Well, downstream of EID were two water users. It was Carmichael, and do you remember, is it Sacramento was the other one? I don't know. There were two water users.
Or probably North or San Juan Water District.
Who were junior in priority to the state filed application.
San Juan Senior.
Those guys did not have Term 91. Only permits issued after 1965 have Term 91. And that's because the board didn't retroactively apply it when they first came up with this thing in the 1980s. So in the 1980s, they had notified people that their water rights might be affected based on a certain cutoff date. And so only people after that cutoff date got Term 91 stuck in their permits. So these guys did not have Term 91 because their permits were issued before 1965. And EID argued that the board could not impose Term 91 on EID in a permit issued on a state filed application. The board argued that it could do that, notwithstanding that there were these two junior guys. And the reason we did that was because we looked at when they would have been cut off if they had Term 91 in their permits and when there was no water available for them without Term 91 in their permits, and it was a matter of only a few days. And so we said, basically EID is stealing water from the projects. Even though they're upstream, they're stealing water because the projects now have to release more water in order to meet their obligations in the delta. So we think it's fair. The court disagreed. The court agreed with the board that the board can impose Term 91 in permits issued on state filed applications, but said that the board can only do so if all junior permits and licenses also include Term 91. So what did that do? Board went, cool. All right, instead of putting Term 91 in permits that are issued after 1965, we're going to notify people that we may put Term 91 in their permits prior to 1965. And that's what people are arguing about now, in part. So, in summary, what do area of origin laws do? They provide a means for people in the area of origin to acquire a right with a higher priority than exports of natural and abandoned flow by these two water projects. They allow area of origin inhabitants to purchase water from the State Water Project and the CBP pursuant to contracts and conditions. They don't get water just because they're in the area of origin, though. They have to have some basis of rights. So they either have to divert under the project's water rights or get their own water rights.
Well, don't they also have to develop a project?
Yes. Yes. What don't they do? They don't independently create a new water right. Again, you got to get a permit from the State Water Board to do that. And they don't entitle area of origin water right holders to divert water previously stored upstream and released for downstream or in-stream beneficial use. That's up to the projects how they want to operate their project with water that they legally diverted into their reservoirs. That fourth category, which I haven't talked about too much, the new watershed protection law is the one that was adopted in the mid-'80s. The State Board implements that a little bit differently. Usually what they'll do is at the time they issue a permit to the water agency, they will determine how much water is needed for future growth in that area based on things like county general plans and other growth projections. And then they create what's called a reservation, setting aside that amount for in-basin users to apply for. That's that Table 13 use. And then they track how much of the reservation they assign as people come in and apply to that water. That's it. These are some resources. You guys are going to get a copy of this, so you'll have that. You don't need to write it down. Or you can always call the Division of Water Rights and ask them questions. They got a lot of people there.
Thank you.
Thank you for the water. So I don't have a clock. How much time do we have left?
We're pretty much out of time, but
Okay.
We could take a few questions, and I would just say that, at the Water Board, there's two rules of water in California, and I think Vicki is amply demonstrating number one, and it's Mark Twain's statement that in California, whiskey's for drinking and water's for fighting over.
I call it the full employment for lawyers.
I guess. This is blood sport at the highest level. Would you agree with that, Dustin?
Yeah.
China doesn't have any water rights. I mean, they don't have a water right allocation system, so they hired me a couple of times to come over and talk to them about, what California did. And my advice was, don't do what we did.
Don't do what we did.
Don't do what we did.
It's better to run it all from the top with a dictator. So are there burning questions that I'm sure Vicki is very capable of answering anything?
I have a question, if I'm permitted.
Yes.
Whoa.
So, Vicki, it's a matter of public record that the
State your name.
Dustin Cooper, legal counsel for the district. It's a matter of public record that the staff at the Water Board is pursuing an unimpaired flow concept for Phase 2, which would affect this area of between a low of 45% and a high of 65%. How, the timing of when this would work or when it would be applied is somewhat uncertain, at least as of today. How would that paradigm fit within water rights and area of origin, county of origin, those types of concepts, in your opinion?
Well, the way that the State Board has been applying Term 91 and area of origin concepts in the past is that it's been treating the Central Valley system and the Delta as a lake. So it's been curtailing people regardless of what tributary they're located on. And the shift in paradigm is that the relative contribution from each tributary is important to the public trust resources in particular, and so rather than treat the whole system as a lake, it's treating each tributary separately. Aside from that, I think it's pretty much the same methodology. It affects slightly the order in which you curtail people, but the basis is that whole public trust continuing obligation responsibility, that the state has a responsibility. It holds It holds fisheries in trust for the people of the state and has an obligation to protect them if it's feasible. And so the real question that I see is it feasible? And in determining whether it's feasible, they look at other options. If we're going to curtail somebody's water use, do they have other water supplies available? Can they use groundwater? Can they use recycled water? Can they desalinate water? Can they implement conservation actions? And those are all pretty case-by-case specific, I think, because people are in different situations. Recycled water, for instance. Recycled water makes perfect sense if you're the city of San Francisco and you got your reservoir up way high in the Sierra Nevada. You run it down a couple of pipes, bypassing hundreds of miles of the watershed, rivers in the watershed. You use it in San Francisco for the most part once, and then you dump it through an ocean outfall. That's not putting water to the highest, most beneficial use of the people of the state of California. Because they have options. They could take it farther down in the watershed. They could recycle the wastewater that they produce and use it for purposes in the city of San Francisco. They're starting to do that now, but they're not doing it to the same extent that Los Angeles is, for instance. Los Angeles uses a lot more recycled water than San Francisco does. So makes sense for them. It doesn't always necessarily make sense from a water supply perspective in upstream areas, because any water that's unused, that's diverted and unused, is returned to the stream. It might make sense if that water is taken out of one watershed, used in an adjacent watershed, because you're cutting off people downstream potentially from access to the water. So the State Water Board would look at things like that, I think, in making those determinations. One of the problems with recycled water is it's produced where there's a lot of people, and it's needed where there's not a lot of people. So cities produce it, irrigators need it. It's expensive to transport water in the state of California, and a lot of people have real objections to putting recycled wastewater in their water supply systems, even though it might not be that bad of a problem to do that. But there's a ick factor associated with that. So you got to look at costs of transmission systems and a whole bunch of other things.
It's coprophobic.
Yeah. Okay, hey, Nick, I think we ought to just close it down for a second. You take a couple more questions.
Yeah, let's take two questions.
Just
Mike,
a couple more questions.
Yeah,
and
could
then
you come to the podium, Mike, please, and ask it?
Thank you very much. That's very informative. Not that I understood it all, but it's informative. I think most of the people in this room are very interested.
State your name.
I am Mike Pasner, Indian Springs Organic Farm in Penn Valley. Thank you, Scott. How is the Crap Dam, the Centennial Reservoir and Power, the proposed Crap Dam, affected by a lot of the stuff we have heard today? I wish we could have itemized which ones affect the potential dam. Maybe you can still do a little bit of that for us.
Well, I'm retired. I've been retired for 2 years. So what I tell people is I'll tell you what I know, but I'm not going to do research for you. So I can't answer your question specifically because I don't have any real information about the specifics of the dam, other than I understand that it is based on a request. It's based on a state-filed water right application. So diligence would be an issue for that. There are advantages to the district, I think, for having a state-filed water right application, which is that you get a 1927 priority. If you're going to file a water right application now or in the future, if you have new water needs in the future, you're going to get a priority of whatever date you file. And water's becoming less available in the state of California, partly because as new development occurs, people are coming in and putting claims on that water. I mentioned sort of in passing that you can't file a permit on a fully appropriated stream. Some of the streams in the Central Valley are already fully appropriated during some months. I expect in the future that the State Water Board will issue decisions that extend the months that those streams are fully appropriated, so you won't be able to get a permit during those months at all. On the Russian River, for instance, the state board will only entertain permits that propose to divert water between, I think it's December 15th and March 15th of each year, which means basically you can only build a storage project. You can't put in a direct diversion project. And you know, that has costs for some people. It's got impacts for some people when we get into drought situations, which everybody thinks we're going to get into more frequently. A lot of the hydrology work that was done for these state filed applications was done based on a very short hydrologic record. The hydrologic record for the Central Valley started in 1922. So this work was done in 1927. So they basically knew how much water had been falling from the sky for about 5 years. We now have a much longer hydrologic record. And so now we know that the period of time they looked at when they filed these state filed applications was relatively wet. There was a drought that started in 1928. But so for the first few years, it was relatively wet. I don't think it's representative of the actual hydrology in California now. I don't think it's representative of the hydrology in the future due to climate change and due to the loss of our snowpack in the Sierras, which is essentially the biggest reservoir for water that the state of California has because it's all stored in the winter and it, you know, is released mostly in the spring as the water melts. It's released in May, mostly April and May on the Sacramento River watershed, and in June and July in the San Joaquin River watershed. Well, we're losing that storage. The water's falling earlier. It's falling more as rain than as snowfall, and you know, we have to have a place to catch it if we're going to take advantage of it. Otherwise, we're going to have water supply shortages throughout the state, and they're going to get more routine. I think each water district needs to look at its options. I listed them earlier. Conservation, water recycling, desalination if you're on the coast and you have access to the ocean, or in some inland areas if you have a groundwater basin that's salty that historically hasn't been used because it's too salty, but you could treat that water and use it, and new storage projects. I think all of those are on the table, and which ones you pick depends on your circumstances.
Well,
And I don't know if I actually answered your question, honestly.
I think so.
Thank you.
Yeah, thank you.
We'll take one more.
One more
Chris.
quick question, then we gotta move on here. Ah, geez.
Hi, I'm Chris Schutz with the California Sport Fishing Protection Alliance. I've dealt with Vicki on a number of occasions. Two questions. One is pretty quick and the other is a little more complicated. The first one is, as a practical matter in the administrative process of processing a state-filed application like the one NID has, like the one El Dorado has that's currently running, how long will the water board allow that to go on? That's the first question.
Processing the application or
Correct.
developing the use?
No, processing the application, different than developing the use, before it's ever granted. The other question is, in the El Dorado versus State Water Board case, there was a Superior Court ruling, and that sort of got reviewed de novo by the appellate court. Mm-hmm. The appellate court said, well, priority is the issue. Now, you've just said that it may be that at some point the State Water Board will go back and retroactively assign Term 91 to everything that goes back to 1927, which would put the state filed...
Yeah, 1914.
Okay, well, okay, to 1914. So that would put the state filed applications potentially subject to Term 91. Yes. The Superior Court had held that because of their nature, state filed applications shouldn't be shouldn't have Term 91 applied because the very purpose was to protect the counties of origin. So my question is, what is your view as to whether there may be another review by a court or the water board of the Superior Court's ruling that it was the nature of county of origin would require that Term 91 not apply. And this sort of goes, maybe a practical question that NID would be interested in hearing the answer to. Thank you.
So the answer to your first question, how long will the Water Board entertain the application, depends on how diligently the Water Board thinks that NID is being in pursuing the application. You know, usually when you're talking about really long time periods, they're associated with the permitting period of the water right. So the Water Board allows very long time periods in certain cases because of drought or other things that go on. Water Board does not usually consider finances in determining diligence. In fact, they usually say they are not going to determine finances. Again, because the whole fundamental idea is that you can't cold storage water rights. I didn't mention this, but one of the reasons that the state board, or that the state of California pursued the Water Commission Act of 1914 is that PG&E and other hydropower operators in California were claiming rights to all of the water of the state. And by filing those claims, there was an argument that they were precluding any other development in the state of California because they had all the water tied up. And so the whole idea was you can't just file an application and sit on it. You got to actually do stuff to demonstrate that you are going to pursue the application to a permit and subsequently a license. The amount of time, I can't answer that question. It depends on the circumstances. In the case of San Francisco, you know, they still haven't maximized use under their confirmed pre-14 rights, and that's been 80 years. The state board, because it recognizes loss of priority issues, has been pretty lenient in giving people a lot of time. But as pressure is applied, that general philosophy might change, and the board members change, so the general philosophy might change. But the parties do have an obligation to be diligent.
I was talking more specifically, asking more specifically about once they've applied for something and all the things have to go, as opposed to what happens after a permit.
Yeah, I understand that, but I don't have a specific answer for that. I think it depends on the circumstances and whether the state board thinks that the agency is making a good faith effort to pursue the application to a permit. I mean, well, actually, the Bureau already had a permit for Auburn Dam, but we canceled that because they weren't doing anything.
After how many years?
Oh,
There's
yeah, a lot.
plus or minus 5 minutes.
And then in answer to your second question, I dispute the statement that you made because the court specifically said the board could impose Term 91 in state filed applications. I mean, that's part of the decision.
The appellate decision.
Yeah.
That's the governing decision.
Yeah.
Yeah.
And if they were going to do it, they just had to do it in recognition of water right priorities and impose it in everybody else's, you know, everybody who's seniors or juniors permits as well. And I don't think the state board has any hesitancy necessarily in doing that. That's my personal opinion, but I haven't worked in water rights for 10 years, and I haven't worked with the board for 2 years. I worked in water quality from 2010 to 2016, but my opinion is, hey, we've done this, it works, it's been supported by the court. The court's telling us we can do it if we do it to everybody else. Why wouldn't they do that in favor of something else? And I don't think that the board will, on its own motion, take up review of a court decision. They just don't do stuff like that. The courts might. The court might, you know, might go to some future case on the same issues, might go to the Supreme Court, and they might reverse. But I don't think the board would do it on its own.
Great question, Chris. Thank you.
Yeah.
And Vicki, thank you so much
welcome.
for coming today.
Thank you.
So why don't we take about 2 minutes and clear the room? I think Vicki and Ken need to be on their way.
Yeah, we're going to take a 5-minute break before the public comment period. It's kind of crowded in here, so if you're
Thank you.
inspired to do something else, that would be fine.
A lot of words.
Okay, we're on the air again. We're back on the air with public comment. Anyone can come here and speak on items that are not on the agenda. We have a long agenda later on, so if you're inspired to be early or quick, that would be great. Short, I should say.
Marin Lipowitz, Cedar Ridge.
Okay.
Anyone
here we
who'd
go.
like to join me in the Earth Pledge? I pledge allegiance to the Earth and all the life it supports. One planet in our care, irreplaceable, with sustenance and respect for all.
Okay, thank you.
Today I'd like to ask who will pay for the dam, and you each have copies. In another life, I commuted from suburban New Jersey to New York City, traveling by train over the heavily industrialized Passaic River. It's an unholy mess, with a lifeless, packed dirt shoreline piled with mountains of debris and waste of every sort as the gray, toxic-filled river moves slowly out to the Atlantic Ocean. The Lenape lived on its banks for thousands of years, constructing river rock weirs to trap the fish they then collected in baskets. In 2014, in contrast, the EPA designated a $1.7 billion superfund to remove 4,300,000 cubic yards of toxic mud from the Passaic's lower 8-mile stretch.
Can I interrupt you for a second? Are you,
What's that?
Does this have anything to do with the district? NID?
Oh, yes.
Okay. Can you relate it to what we're doing?
Can I take that time off my time?
Sure.
Thank you. You could say that the Passaic River is a sacrifice zone, a costly sacrifice made on the altar of capitalism and commerce. Wikipedia says, in part, a sacrifice zone is a geographic zone that has been permanently impaired by environmental damage. The Centennial Dam's destruction of the last 6 miles of the Bear River would once again heavily impact the Nisenan people. The Bear River, Nemseo, Kumimseo, Tuimseo. Shelley Covert, Secretary of the Nevada City Rancheria, asks, how many dams can one stretch of river endure? It's like stretching a rubber band really tight. I believe we, like the Bear River, may be stretched so far, another tug might be the last. When will enough be enough? And in reply, Elizabeth Rogers comments, Shelley wisely speaks of her people being stretched to the limit like a rubber band. I unequivocally state that the same can be truthfully said about the entire human species. If you are upper middle class, as are most policymakers, then there is a delusion of safety, a delusion. How thin is that membrane? How much further can that which sustains us all, our source, water, and earth systems, be stretched until the tipping point of our very life support systems is reached? The Centennial Dam would unequivocally make the Bear River and its canyon a sacrifice zone. Who will pay?
Thank you. Is there any other public comment? If there's anybody else, can they stand up here after Mike? Anybody else? Go ahead, Mike.
Morning, board and employees. I'm Mike Pasner, Indian Springs Organic Farm in Penn Valley. Been farming with NID water for 32 years. Let's start with transparency again. It's still a problem. The Vegetation Management Working Group meetings are not open to all stakeholders, never mind all ratepayers. Why is that? I've asked that question many times. I do not get an answer except no from the NID board. If you were to open it up, maybe 4 or 5 or 6 more people would come with good ideas. The current 12 members are handpicked by Rem and Brian. Why does this group report back to the Resource and Maintenance Committee? The group should be open and stand on its own as a committee. Scott's Flat security fencing is an example of you deciding to open discussion with public input on an issue. You are the ones who decide whether a working group is open or closed, and what is a committee. Another action lacking transparency is the Crap Dam, Centennial Reservoir and Power. In 1927, it was called the Parker Proposal. General Manager Rem Schertzinger renamed the project a little more than 3 years ago, to commemorate NID's 100th year of operation. The hydrology report on this proposed dam has been out for over a year. We, the ratepayers, paid for it. Why can't we see it? The ability of private hydrologists to review this report would be very honest and telling as to the viability of the proposed Crap Dam. NID continues to put the aquatic herbicides Captan, Nautique, and Coutrine directly into 350 miles of irrigation ditches. Dripping this elemental copper toxin into 350 miles of ditches is NID's best method of ditch maintenance. 33 of these miles are what NID calls randoms. We know them as natural creeks. I want to know how many of these randoms have these aquatic herbicides dripped into them. Is it legal? I've been asking this for 5 months and filled out a public records research request, and still no answer. Remen says I'll get an answer. We'll see if I do. How can we trust you to perform an open, thorough, and factual raw water master plan? The plan is supposed to represent the next 50 years. No one can plan on the next 50 years of water use in California. Maybe 2, maybe 4 years would be more appropriate. Lastly, it looks like my prediction of NID board needing to hold meetings at the Vets Hall in Grass Valley due to the number of concerned stakeholders is coming to fruition for your next board meeting. Thank you.
Thanks, Mike.
Diana Suarez, Colfax, California. Watching the water rights presentation brought to mind the people whose water rights have been denied since the beginning, and that's the Aboriginal Indigenous people of the Bear River. In the total decimation of these people, I hope that this group of people who have come upon the land and taken the water, would keep in mind maybe even a spirit of kindness toward these people and not decimate their culture and their last connection to the Bear River. And I just wanted to remind this group, there was people here before, and it was their water. Thank you.
Thank you. Okay, thank you. That ends public comment. So now we're going to move to the consent agenda. Are there any items to, actually, there isn't any items to pull.
Motion to adopt the consent agenda.
Second.
Motion second. Roll call.
Division 1,
Aye.
Division 2,
Right?
Division 3,
Aye.
Division 5,
Aye.
Division 4.
Aye. Okay, moving to general orders, comprehensive annual financial report 2017.
Good morning.
Morning.
I am Debbie Martin. I'm the controller here at the district, and I am acting on Marvin's behalf, who's on vacation. So he has left this project to me, which is really appropriate because I'm the one that kind of put all the detail together. So
All right.
we are bringing forth our financial statement audit for the year ended December 31st, 2017. And before I get
question,
in,
Jim?
yep, yes.
There was a couple of the miles of canals bounced around. At one point it's 475, another time it's 460.
Yes, yes.
You aware
So,
of that?
yes, I am aware of that, right?
Just no way it was changing.
Well, you know, that's interesting in trying to, in reviewing the report and going through, being new to the district and learning what are all of our benefits to us, what do we have, what we don't have, and reviewing the website, previous documents, and putting together this information, what has been reported out before. So I will take note and, you know, make sure we,
Come up with a number.
close some loops on that. Yeah. So this is usually a coordinated effort between, you know, many people in getting some of this detail together. So the introductory section, and actually I expect that this particular bound copy when you get there, will be expanded in the future so that we will have much more information from the divisions and, a pretty well-prepared report that has a lot of information, because this is our flagship of what happened to us last year and what we did. And I'd like to see that,
And that's a gracious answer. You could have just thrown Marvin under the bus there, but a very gracious answer.
I am not going to do that to my boss.
Compiling a lot of So Rem comes up with yet another number?
It's
Yeah.
475.
Oh, it is 475. Okay.
Okay.
It was one of the numbers in there. It just.
Okay. Well, I'm going to go through and flesh out all those if there's anything else in there that doesn't come out properly. So, so first I want to thank the board. I know this is September, and it has taken us a great amount of effort to produce this project. And there's many reasons why. We were trying to complete our centennial audit on top of our year-end audit, and usually our year-end is very, very difficult and very time-consuming. So completing the centennial audit on top of this kind of delayed us a little bit on this. So. So here we are with blood, sweat, and tears with our project done for you. And I want to thank you guys and thank Rem too for giving us that grace so that we needed another month or two to kind of wrap things up, and for our very patient auditors, Richardson and Company, for helping us get to this finish line here. So. There's a lot of financial information in here. This particular report tells us not only where we've been, but where we're going. And the important piece here is there's a management's discussion and analysis in the introductory section that talks a lot about our finances. And Ingrid Scheiplein from Richardson is going to highlight a few things, but I did want to mention that the district did quite well last year and managed its resources quite responsibly. So I'm going to switch gears from water rights and talk a little bit about finances. Just briefly, we have a lot of information in the document itself, so I'm not going to review in great detail a lot of the finances because it is incorporated in here. However, the district at the end of the year accumulated $13 million in unrestricted liquid cash. So we've got plenty of resources on hand to manage expenses coming up, and we're in a great position. Marvin does a lot in the investment with Rem's advice as well. We've got a lot of money available in long-term investments, but in liquid cash readily available for us. We're very strong. Our assets exceeded our liabilities by $411 million. Not a lot of people even or entities can speak positively about that, and that's good. We own more than what we owe. So this year we landed at $411 million assets over liabilities. So we're looking very, very strong there. Our net position increased $13.4 million. So our net position is really kind of our net worth. And primarily what we did with that increase for us is we invested in our infrastructure. So we replaced and we expanded. And that's a good sign when businesses can reinvest in themselves and grow. So we did very well with what we were given. So I'm going to talk a little bit about the opinion of this audit, which is really sort of the point of this, not to mention just reporting out on our results of operations, but also an audit at the end of the audit should tell us what the auditors think of our financials. We earned a clean opinion, an unmodified opinion. So that's the best that you can get. And so I'm very proud of what we've done with our finances and our reporting, and to earn that opinion is no small feat. Richardson and Company is a very well-respected CPA firm, very high-quality CPA firm. They set a very high bar for us to get that opinion, and so we successfully did what we needed to do to earn that opinion. So with that, out of the audit usually comes some recommendations, some findings that we need to attend to. And you'll find that in the audit report at the end under compliance section. There's a report called a report on internal controls. And in that you'll find findings that we need to work on. And when we started with Richardson back in 2013, we had 10 findings. And like I said, they have a high bar for us. So we hadn't seen those before, but when Richardson came along, they said, you need to do this, 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 and this. And I'm proud to say that 4 years later, we are now gone from 10 findings down to 2. We reduced and we eliminated another finding this year. So we're working very hard at removing those findings and doing what we need to do. The last two are the ones that I want to spend a little bit of time on to talk about what we're doing and where we've been, what we're doing now, and what we're going to do proactively to remove those findings. And those are going to be some slow boats to turn around because those are some very complicated findings. And they'll take a lot of effort. So we may not see that we remove these findings next year. It may take us another 2 years. And part of that is because we need to remove our antiquated accounting system. But let me talk about the findings just a tad. So the first finding that's there is our closing process, our year-end closing procedures. So our closing process currently with our current system is very, very difficult and very challenging. I have a 20-page checklist because of the way our system operates. And the reason why this is so important is we currently run our budget reporting on a cash basis. So I call it like checkbook accounting, right? Cash in, cash out. Very simple to do. But we are mandated by government and by the water code for us to present in accrual basis, which is a whole different methodology of accounting. Basically what that is looking at every transaction that we have and looking at, like if we're looking at revenue, it doesn't matter when we receive that cash, it matters when did we earn it. And there's a whole methodology behind how you analyze those transactions. And the same thing for the expense side. When did we actually receive those services or receive those goods? So at year end, we have to analyze our transactions and decide what year does it belong to. In this case, was it 17 or 18? Doesn't matter when the cash flowed. So converting our books from that cash basis to this accrual basis that we're mandated to have is a very lengthy process. So we need to shorten that gap. The reason why it takes us so long is kind of multi-pronged, but it is one of the reasons why it delays the audit and frustrates our auditors because we're not ready for them when we need to be. And we are working very hard to try and turn that around. So one of the things that we've done is especially since I've gotten here, but it's been, a multi-person approach. But we're looking at every single process and kind of retraining individuals to think in accrual basis versus cash basis. And that's a very difficult concept. So if you're not used to working with it, it kind of gives people a little bit of, step back of figuring out how I don't understand because they're used to running just their checkbook. And this is a very different methodology. So there's training involved. One second piece that we needed to do was to replace one of our long-term vacancies in accounting. Accounting's been running shorthanded for well over a year. So we put a permanent placement in there. We've finished that recruitment. And you met her at the last board meeting, Valerie. So bringing in another person who's very accrual basis oriented in her accounting will help us close that gap as well. And the last, of course, and I alluded to, was our extremely challenging accounting system. So I tease Rem all the time that the accounting system is our truck, and I need my truck. I need my truck because we're a very large entity. We have a lot of transactions, and to have a workhorse that is kind of needing to go out to pasture is challenging for us because it leaves us with a lot of manual processes when we should be having a little bit more efficiencies. So we're really looking forward to that.
You're talking about software?
Software, yeah. Yeah, we have an 18-year-old software program.
Pendamination?
Yeah, yes, that I like that. Yeah,
I coined it first.
We might have a little bit stronger terms behind the scenes, but that works. So, the year-end closing process very challenging, and we're doing everything we can to kind of close that gap. And I would love to stand before you in April or May and have this thing done instead of September, but this is where we're at, and this is where we're trying to fix. So the second piece that you'll see in there is with respect to recreation. We've had this weakness in our cash handling at recreation, and it kind of expands more than just taking in the cash and making the deposits, how we handle it in general. There are some challenges there. We can't use a lot of technology in some of the areas, but they would like to see us work a little bit better at managing our cash and how that information flows to accounting. We need it early, we need it often, we need it daily. And trying to get through that finding, it'll take a little bit of time. We did a lot of work this year, actually, and I harassed Monica quite a bit. She's nodding. But we started looking at recreation and looking at the findings that the auditors were asking us to look at and to make changes. And so early on, I started, having a lot of meetings with Monica, talking about our challenges and what can we do from her perspective, getting her experience. My not being out in recreation, I needed, that to look at, and that's my job as the internal control. So I started working with Monica. Then we initiated a big meeting with Rem, Monica, Marvin, Monica's staff, my staff, and we all had a little powwow, and we all sat and talked about where do we want to go, what do we need to do, what can we do, where can we go with that. So we kind of put a baseline of some ideas of what we needed to do to move forward. So we're working on those initiatives. Accounting actually went out to recreation. We did some on-site visits. We sat and watched what they do and got a feel for that. So we can develop some best practices and make recommendations. So once recreation is officially closed, that's what we'll be spending our time with in this fall, is to get rid of that finding. So as long as I'm alive and breathing here, I will get rid of these two findings, because it's ugly to look at as a CPA. So we're definitely doing all we can to kind of move that. And again, back to the accounting system. We expect that our new accounting system is going to help us tremendously, and especially in recreation, to kind of enable her team to move that data over to us in a much more efficient manner. So those are the big findings. In the management letter is an additional recommendation that we need to work on, and this one is going to be a bit of we're going to need a lot more staff to kind of spend time working this, and this is how we account for our capital assets. Budget-wise, we have buckets of money, and we say, okay, monies go to this project and that project and that project. Well, when you're looking at it for financial statement purposes and you're going to book that as an asset, as we say, that's a different methodology than here's where my monies are. For that project, we have to look at and say, does it qualify to be included as part of our infrastructure as an asset? And that's a different methodology. So we have a lot of projects. As you've seen from our project balance report, it's 30, 40 pages, and the first 10 of it are ones that we have to deal with in accounting of what do we do with this thing once we kind of see it slowing down and it's placed in service, and start that analytical work. So our capital assets accounting, traditionally for every entity, is difficult. There's a lot of work, and we're a very busy entity. We have a lot of projects out there that everybody's working on. So accounting has to tag in with a lot of different divisions and get information. And you're dealing with, they're busy too, and we're coming on year end. I need that answer now. What did you put in? What did you take out? So we'll be working much more diligently on trying to close that gap and getting that information. And Gary's team so far has been very helpful for us in engineering to help us start getting that process early, often, frequent. I need that information. So that's really all I wanted to talk about specifically is, what are we doing to kind of fix these things and get these out of here, because they've been sitting there for too long. We need to get them out and get them done. So at this point, I'm going to turn it over to Richardson and Company, and Ingrid and Bob are going to give you some highlights of the audit.
Oh.
Question? Hi.
Hi, before you leave,
Yes.
I appreciate all of your efforts
Thank you, because
to
there's a
get
lot of
us
tears on this.
without dings on our report.
Thank you.
I've sat here too many years and heard these and knew of them before I started hearing. I knew of some of them. I'd appreciate it if before the end of the year you could do a timeline of what things need to happen and how you're going to do that in the next year, so that it gives the board some kind of feedback. For instance, when there's a personnel problem and it takes 6 months or so to get somebody replaced,
Yeah.
that's an issue that,
You need to
I
hear
realize, Rem, you are the general manager, and I'm stepping on your turf.
You're talking to me.
Yeah. But we could give support where we might not, because sometimes it's a where are we going to spend the money sort of thing.
Well, right, and I hear that. I think that's why when I sat with Rem about this program, and he and I were on the same page, I really wanted to talk about the findings, because very often when entities present findings in audits or just even their audit, they kind of don't deal with the auditor recommendations. That's their job, is, not only to offer the opinion to us or tell us what their opinion is of our audit, but where do you as professionals, to us professionals, what do we need to work on? What do we need to fix? How do we get better? Like I said, Richardson is a very high quality organization, and we want to be that same quality. I want that too. My name goes on here too. I'm CPA. I don't like to do work that's low quality. So I want to see us move forward. And I think, that's why Rem and Marvin decided to bring me on. And you do need to hear those things of where are our difficulties. Staffing is one. Education and training is one. I need my truck, which is my biggest priority. I need that accounting program. We need it updated. We need to abandon it and move forward, which we are. In fact, the kickoff meetings are starting next week.
Well, that's
too.
So, Director Weber, what I'd be happy to do is we can put this as part of our quarterly update. We can update the board on the findings and our progress on those findings as part of that process.
But I also asked for a timeline for when things are going to be implemented. Are you fully staffed now?
Yes.
We are at the moment, right?
Within what parameters have been given to you?
All FTEs are fully manned.
Okay.
Yeah.
Okay.
Yeah.
Thank
Yeah.
you.
We are fully staffed right now.
So before the end of the year, if I could get the timeline,
Okay.
what items you're going to be implementing and the timeline for getting to those.
Okay. And as I mentioned, these findings may take more than a year, especially because the ERP system will not be done by next year. I imagine we may implement in 2020, not in 2019. It won't happen.
What are you implementing in 2020?
We won't be fully live.
We won't be fully live in the accounting system.
On the software?
The software, yeah.
The ERP, the Enterprise Resources Program.
So why does it take that long? We've been talking about it for 3 years.
They usually take like 5 years.
Yes.
So when we establish the chart of accounts, we bring the system live, we run in parallel with our existing system so we don't lose any information.
Right.
Then we sacrifice or burn the boats. We start live on ERP, then we migrate the ERP into all divisions.
Okay.
It takes a very long time
Okay.
Yeah.
to do it right so that we don't have another penimation problem.
What's the approximate cost of the new system? Is there one?
We don't have,
Well, so the budget right now I think has about $1 million in it.
I don't have the budget in front of me.
I need my
Sorry.
budget.
I'm
But
sorry.
yeah, we've put a lot of money in it.
Yeah.
So that
I think
covers
it
it,
got-
pretty much? The new truck? Is that what you're
Yeah.
It's not a lot for a truck.
Big truck.
Big truck. That's coming before the
The
board.
amount of time that you would save, would think.
Right now, in the
than cover
budget
that.
is for
I know
our
it's prob-
consultant. We've engaged, we went out to bid, engaged a consultant to help us with this conversion. You do need outside help to kind of manage it because it is a huge undertaking because every single division needs to have their input of what their pain points are with our current system and have them analyze us.
Oh, yeah.
What is it? What do we need to do? Where do we need to go to get more up to date? So our kickoff meetings will start next week to start having those individual sessions with each group in accounting, purchasing, hydro, engineering, and that to kind of get all of that information together. So we're starting that process, but we know we're not going to be buying a program this year. It's September already, but we've got to get through all of those. But I imagine by early next year, I would suppose that we'll be going out to bid and then start the selection process to review software, what's available, what's out there, what may fit us, and go through that.
All right, thank you.
Okay, I'm going to turn this over to Ingrid.
Good morning. Get this readjusted here, my height.
SUM.
To start by just discussing the reports that we issued as a result of this audit. We issued an opinion on the financial statements themselves, which is this larger document. Oop, wrong way.
Yes, the bottom
Yeah.
button. It's
Okay,
counterintuitive. I apologize.
We also issued a report on internal control and compliance. It's also within this document. We issued a separate letter containing certain items that we're required to communicate to you. And we issued a management letter with various other recommendations. We're going to touch upon these reports in the presentation today. Just some of the audit results and observations, just an overall summary. We issued a clean opinion on the financial statements, so that states that these financial statements are fairly presented. However, there were a large number of adjustments needed to get to that clean opinion, which we'll discuss in the presentation. Then, as Debbie addressed, there still were delays in the completion of this report, being 9 months after the end of the fiscal year. That's due to the staffing issues. Debbie just came on board, seems like forever, but it's only been a little over a year. And then she had her right-hand accounting person. She was basically a vacant position for probably a year, over a year. So she has her accounting staff, I think, just started earlier in 2018. So that's created challenges. And then the centennial audit, that being a high priority, them preparing for the document, pulling the documents together, also caused delays. We do have, as Debbie pointed out, just 2 recommendations that are carried over from our 2013 audit, but no new recommendations for improvement. Just to cover a summary of the financial statements, the page references here are within this comprehensive annual financial report. I'm not going to actually turn to those pages, but just have an overall summary. Overall, you have a positive net position or equity of $37 million. Most of that is in the electric fund. The water fund actually has a negative unrestricted net position. And that's mainly because of the pension liabilities. The unrestricted net position for the Water and Recreation Fund, the board has designated certain amounts that are described on page 34, but there isn't enough actual net position available to designate because of the negative net position of the Water Fund. The good news is that all of the funds had net income during the year, have the amounts listed here. The Water Fund actually had a net loss last year of $765, so it's now in a positive position. Electric Fund had a net income of $12 million, which is pretty comparable to last year. Recreation Fund positive $240,000. There were capital projects during the year. Expenditures were $25.9 million. All of those were funded with your cash reserves, so there was no debt that was secured to fund those projects. So I mentioned no new debt. There were debt repayments on your existing bonds that you issued a couple of years ago of $2.2 million. You'll also see on that's highlighted on page 37 of the financials, the increase in the pension liability. The annual cost as well as the interest that's accumulating on that pension liability is higher than the actual contributions made to the plan. So that's resulted in a $5 million increase in your net pension liability. So that liability is now at $49 million, and that's really what's driving that negative reserve in your water fund, is because of that pension liability. It doesn't represent amounts currently due, but the amounts that potentially will need to be paid out when your current employees retire. As far as OPEB, which is the other post-employment benefits, which are the health care benefits for retirees, at this point in time, the amounts that you've contributed into the plan are in excess of the requirements by $612,000. So you actually have an asset for your OPEB compared to a liability. We'll discuss later that is going to change as a result of a new pronouncement that requires the full amount of the liability to be recorded. Also in that document is a report on internal control and compliance. And as I mentioned, we have no new comments that were added to this report. The carryover comments, there was one comment that was in last year's report. There was a carryover comment that was addressed during the year. And then there's 2 comments remaining that need improvement. So the 2 items that we have listed in the report, we have classified those as material weaknesses. The one has to do with, as Debbie discussed, there are several areas that we've listed out where accounts are not being analyzed timely to ensure closing of the books in a timely manner. While some items have been addressed, there's still improvement needed to ensure that the books are closed on a timely basis. And as I mentioned earlier, the progress with addressing this finding is due in part to the shortage of qualified staff, as well as the system really not allowing for a lot of automation in those processes. So we continue to recommend that procedures be put in place to ensure the timely closeout of the books. There's also some additional improvements warranted in the cash handling functions at the recreation divisions. There have been improvements since we first brought this finding up in 2013, but there are still some additional areas that can be improved that the district is working on. The next items I'd like to turn over to Bob Simons.
Good morning, everybody. Ingrid is our main lead. I'm the one that's here all the time. On the required communications letter that we issued, the details our requirements and our responsibilities when we undertake an audit. Most of it is fairly, boilerplate, but there are some areas that we'd like to highlight. During the audit, there's difficulties encountered in performing the audit. I think we talked about that a little bit. We usually were trying to start this audit, in April or May, and here we are in September. So Debbie's, due to the staffing issues that she had, there was a shortage of people that understood the accrual basis of accounting that these statements have to be issued under. This is not necessarily a strict government. It's an enterprise fund. It's treated accounting-wise like a business, like a regular business. And so consequently, the account analysis that has to be done when you go from your checkbook, like Debbie said, to an accrual basis takes a lot of effort. And if there's only one or two people in the department that understand what accrual basis is, then there's a lot of pressure on just those individuals. She's added staff that give them a lot more of a breadth of experience in accrual. So, but the difficulties that we did have are not all the account analysis were completed prior to us starting. There's still a large number of adjustments. The staffing changes that have since been addressed contributed to the delays back 5 or 6 months. And then some of the accounting processes that are undertaken to get to the point where something can be recorded in the system could be streamlined a little bit. The new system that the district's going to be getting in the next year or two will fix most of that, but I think some of the processes to get to the point where you can put something in the system need to be reviewed also, so that it's more seamless and less time consuming. We had, during the audit, 119 adjusting journal entries that were identified, and 9 unadjusted audit differences that are attached to the letter that we determined to be immaterial.
Bob, that's down from last year, right?
It's a little...
Were we 140 last year?
Well, I think it was more like 84 or something.
Oh, okay.
But
Yeah.
the account is up because some of our staff can make a journal entry one by one by one. So
Right. Rather than write it on one page and
page,
do
yeah.
3 or 4 on one page, they issue, one at a time.
Oh,
Yeah.
And so that could contribute to the big difference.
thank you.
So this is the required communications letter. I'm going to talk about the management letter next. I think it's been discussed already, the accounting for the capital asset transactions. The project system currently that's being used, when district opens a project, there's, a lot of different expenses that are related to that project. Some are capitalized, and show up on the books as a fixed asset or a capital asset. Others are expense items. Being able to differentiate those is huge in order to fix some of this accounting for the capital assets. And hopefully the new system that you all will be getting will help with that. And then Debbie is an excellent trainer and can show anyone what accrual basis accounting is, and we have confidence in her to be able to do that. And so she's continuing to train everybody while trying to push the ball forward. So, and then I guess the last thing is that in the 2018 audit there will be a new pronouncement that will have to be implemented by the district to accrue the unfunded OPEB liability, which we approximate to be about $11 million. That'll become a new liability on the balance sheet and a further reduction of the net position of the district.
So Bob, if we did that now, then we would be taking the 37 million and then deducting out the 11 million, leaving us with 26 million.
No, it'd be the other way.
It'd be the other way.
Actually, yeah, it does, the 37 million of net position that I mentioned that you have, it will reduce that.
Right.
Yeah.
Okay.
And most of that is going to hit in the water fund that already is the negative 7 million. So it's going to cause the unreserved balance in the water fund to go even more negative than it is.
Yeah. Anyways, does anyone have any questions that we can help you with?
No, right on.
I want to thank Debbie and her staff. I know we bugged her over these last few months to try to keep things moving, and so I know she worked hard to get to where we are now, and as well as training her staff at the same time. So we do want to thank her.
I
and
did
her
have
staff.
one, I'm sorry.
Sure.
It's on page 9. It has to do with investment income. It's just a short question. It's investment income in 2017 was 2%. Is that just based on CDs and bonds?
Page 9.
Yes.
CDs
The
and bonds.
management decision.
Yeah. So the investment income is, managed by Marvin. So he follows what we're allowed to, either through board policy or by code, what we're allowed to invest in. So pretty much we're dealing with some very safe investments, no hedges, no derivatives, anything pretty extreme. Very, very conservative investments, federally insured bonds, and that type of thing.
And the taxes and assessments are 18%. Do you divide that by? Do you ever divide that by county?
We do on the detail level, because we do get those cash receipts in separately from Placer County and Nevada County.
Do you know approximately what the percentages would be?
Off the top of my head, I don't.
It's kind of because it's not in here.
Yeah. Oh, yes.
I mean, it could be, but.
I don't actually know that off the top of my head, and I'm sorry that I don't know that piece off the top. So I'm still learning this, but
just a matter of curiosity.
Yeah, it hasn't fluctuated over the years. I remember it being fairly consistent, but I don't actually know that off the top of my head. So I apologize.
I noticed at the very beginning, it spoke about the two counties, and one county appears to be in sort of a robust growth, and the other one is stabilizing.
Right. Yeah, in fact, when Marvin was writing this, he actually went to their CAFRs and gathered that information about the counties, because each entity needs to put together some information about economic factors. And, we are impacted by Placer and Nevada County. So it's appropriate for us to include what information they've garnered about the economic conditions that are affecting them, because it also affects us and our tax revenues.
Okay, thanks.
Sure. I do want to take a moment before we close out. I have some staff members here in county, and I want to thank them too, because without them making sure the lights are on and the employees are paid, as you notice, we have no hitches in getting your paychecks out to you, and the lights are still on. So I would just want to take a moment and thank my staff too, because without them behind me, I couldn't have gotten to this too. So thank you guys for all your hard work and having my back. I appreciate that. So thank you.
Is there any?
So board, we need a motion to authorize the finance manager to publish and file this report.
I make a motion to publish and file the audit.
Second. Is there any public comment? No public comment? Motion in a second. Oh, I think we got one. You got caught between the.
Yeah.
Almost got it.
Otis Wallen from Colfax.
Good morning.
Yeah, good morning. And how is it that we can find answers to some of the questions that we have about this? An example of that would be on page, page 2, it says the unrestricted assets are 13 million, yet on the chart on page 51, says the unrestricted assets are 37.5 million, and that was just highlighted here. There seems to be a difference in how those things are either stated or presented, and it's all within the same period of time. That's one issue. Another would be the debt service coverage. There are distinct differences between two reports that you've had this year on 2017 debt service coverage. One has your debt service coverage at about 2.91, and the other is over 5. I mean, they both indicate that you're sensitive. Your debt service coverage is sensitive to a relatively small borrowing. So there's a takeaway there that's the same in either case, but nonetheless, the figures for the same year, I'm seeing two different figures. So how is it that we can ask these questions? Is this best done in writing? Is this best done in a public session? What's the?
I don't know if would you want to answer it now or answer it later?
No, we'll take the question and we'll respond back to Mr. Wall.
Okay, that's a respond back.
Okay,
We'll have to get
it's emailing and
We'll track it through Chris as a PRA.
Okay.
Okay, motion second. Roll call.
Division 1.
Aye.
Division 2.
Aye.
Division 3.
Aye.
Division 5.
Aye.
Division 4.
Aye. Alta Sierra Reservoir Replacement Project. Who's up? Oh, I was wondering where you were. Gary King.
Give me a second.
Good morning, board, public staff. My name is Gary King. I'm engineer manager for the district. This is item number 4. It is the Alta Sierra Reservoir Replacement Initial Study Mitigated Negative Declaration. It's FATAR number 6971. The intent is to conduct a public hearing and adopt a resolution number 201823, adopting a mitigated negative deck and approving the project and mitigation monitoring and reporting plan for the Alta Sierra Replacement Project. Today, as far as being subject matter experts, I have Stephanie Rasmussen from Ascent and Sydney Coachworth from Ascent. They wrote the document. I also have Fred Waymeyer from Operations, which will give some feedback on the issues that we're dealing with this. And Brian Powell is here also to give support on the maintenance issues that we've been dealing with on this project. At this point, I'd like to discuss what the project is. As you can see, the existing Alta Sierra Reservoir is a hypalon-lined reservoir. It is aged. It was built in 1996. To give you an understanding of the issues with the hypalon reservoirs, we brought a piece, one of the happy pieces, out of the reservoir from the Banner Taylor. It had multiple repairs. This facility does not have as multiple repairs as a Banner Taylor, but is going that direction extremely fast. The reservoir is located on two pieces of property. Both properties are owned by the district, and it's located in Alta Sierra. Yes, sir.
Is this a public hearing, and should it be opened at this point?
No, sir. I'll open it up in the future
After
slides.
the presentation?
Yes,
Okay.
sir. So then the public will have something to give feedback on. Sir.
Okay, right on.
Here's a view of the hypalon lighter. As you can see, it has some repairs in there. It's hard to see. We also have standing water in there, and also we have some vandalism problem where people get on top of it. Here's another picture of the existing berms, similar to what we had on Banner Taylor Tank. We're also surrounded by trees in some of the areas, especially in the back lot line. The project need, it is an age facility. It has a hypalon liner. Liner is vulnerable to vandalism and wildlife. It also needs repairs are problematic. We are dealing with the same problems where we have to float, lift the old liner up and do repairs on it. That is very tricky for maintenance. And it's starting to behave worse and worse, similar to what we had with the Banner Taylor Reservoir. And with that standing water and rips in the facility, it can cause contamination issue and vulnerable to age. Pros project description is to replace the existing reservoir. And with two tanks with the same footprint, provide for a secure storage facility. With two tanks, we get operational flexibility and maintain treated water service and provide site improvements. Before I keep going on, I need to go back a little. I would like to ask if there's any questions of the operations department. Fred Waymeyer is happy to answer any questions about the operational issues. And then Brian Powell can answer any questions that are on the maintenance issues. Okay. At this point, I'm going to continue forward. The CEQA process, we did this mitigated neg deck. The 30-day public review period started on September 19th, and then we're having the meeting today at 9 a.m. Notifications. The district, the M&A was mailed to all the residents within 300 feet of the facility, even a little farther in some of the spots, on August 21st, 2018. Notice was filed with the clearinghouse on August 21st. Public meetings were held on March 20th, 2018, and recently on September 13th, 2018. Notification of the public review intent to adopt was published in the Union on August 21st. And copies of the document available at the front office here at the district and also at the Nevada City Library. And it's also been on our website. Yes, sir.
How were those meetings attended?
The first meeting, I think we had about four or five on the first meeting. That's the March 20th, 2018. And on the September 13th, 2018 meeting, none of the residents contacted us. We've had a few phone calls. The biggest concern is asking about that they're going to maintain their current water service because people are very attached to that. These are the impacts. Water service that we see is water service will be maintained throughout the project. Brief planned interruptions to do some connections, but that's normal. We'll notify the residents ahead of schedule. There's potential significant impacts. Now, significant impacts means us working in the area. Those have been mitigated down to less than significant, as stated below. Project mitigations, as required by the federal law, is we have the pre-construction surveys for nesting birds, inadvertent discovery of historical or archaeological resources, environmental awareness. If there's any animal, we do a simple 2-hour, if I remember correctly, orientation to the people in the field. If we find any human remains, it seems to be an issue, so we find it, we'll do appropriately. And then prepare a health and safety plan that's more related to dust control and other items like that. Traffic control plan, we're really not going to affect many people in traffic control other than having the heavy trucks come in, and that will be handled. It'll be very limited. In the mitigation measure, it says 20 minutes max. And then any ground service disturbance site visit. What I mean is when we first start digging ground, the archaeological groups have indicated that that they would like to be there. The project timeline, we anticipate going to bid. Actually, we're starting to move forward on that, but we're planning to go bid next week. It will be done, just so we're clear about it, we're going to do it as a design-build project, similar to we did Banner Taylor. Take about 1 year, and then we'll have additional meetings with the public around there, particularly discuss about the color schemes of the tanks, because it's going to be, as indicated in the CEQA document, the tank is going to be higher, and also that we are going to improve the current plantings around the facility to such, and we're going to have the public input on those plantings. That has worked well with us on the other projects, and so we'll integrate with the public on that. At this point, I would like to discuss the budget, which is, did I go backwards? Yep. The budget for this project, it is currently, there's a budget of $1.7 million in 2018 and $2 million proposed in the 2019 budget. And the estimated cost for this project is about $3.5 million. So that's what we're, to go over the budget, which is important. This comes out of non-programmatic budget for the engineering department. At this point, I'd like to not jump around. I'd like to open public comment, if that's acceptable with the board.
I have a bunch of questions. When would you like me to ask them?
We can handle them here before the public comment, Director.
Thank you. So what's the size of the tanks, the two tanks?
2 tanks. We're looking at, we're going to do we're going to bid 3 million gallon, 4 and 4.5 million gallon tanks. And why we're doing that is our existing size is about 3 million, but we need it for future expansion, future issues that are coming on. In addition, these tanks now support Lake of the Pines through the new BEP line once we get that in service. So this is no longer just an Alta Sierra tank. In the future, it will be a whole regional facility. So what we're going to do is similar to what we did in Banner Taylor. Is our base is 3 million, which is replacing existing. Then we're going to see how much it costs to go up to 4 million and 4.5.
Okay. What will be the water supply in the transition between the existing tank and these?
Excuse me?
What will be the water supply when the tank that exists now is eliminated and 2 new tanks are put in?
The water supply will come off the existing system, coming down from, and Fred can answer this better, but of where the water comes from for Altus here, but we will not be terminating this.
Yeah, Fred Waymeyer, Treated Water Superintendent.
Can't hear you.
Fred Waymeyer, Treated Water Superintendent. So currently we have a valve station at the reservoir that supplies water to that. We bypass the reservoir using the valve station, and we set it up in PRV mode, just pressure reducing valves. So we tested that this summer and it worked fine.
And the water supply is Osborne Hill.
Right, yeah, it comes from Lomarica, the same Osborne Hill.
Thanks.
So it's the same supply that goes to the reservoir. We just bypass it right at the reservoir.
Okay. Thank you. What's going to happen to the raw water storage tank that's there?
There is no raw water.
It's treated water.
It's a treated water reservoir. It used to be.
Well, I'm sorry, but there's a comment in here that there's an existing 3 million gallon earthen storage and it will be left.
That's okay. I think let me clear that up.
Director Weber, what page are you on?
I think you're on the history.
I can't, I didn't write the pages. I
Okay.
had so many questions that I was trying to get through it.
That's a very good question. Let me try to answer it, is I think you're talking about the history. This historically started as a raw water reservoir before it was an earthen dam.
And then it was converted.
And then we put the Hypalon liner and turned it into a treated water system. And now the Hypalon liner is failing.
Okay.
And thus we are now replacing that with 2 tanks. Those 2 tanks will support the area.
Gotcha.
And they'll be inside the footprint of the existing reservoir.
Okay, thank you. The trees that are around the site, are you keeping those?
Yeah, we don't have any intention to getting those trees,
Good.
and the reason is because it's outside the berm.
Okay. I think when you start working Saturday and Sunday nights, which was mentioned as a possibility, you might have some difficulty with neighbors. That's my experience on the Banner project. So I'd try to avoid that.
We try our best to do that. Sometimes we're put in a corner if a storm's coming in that we need to get work done before a storm shuts down construction. We do that, but it's very, very rare.
Be well to notify the neighbors ahead of time.
Yes, ma'am.
In terms of safety issues, if you're going to work through fire season, having a fire protection plan that's filed with the local fire districts is important. That was one of the deficits on the Banner project. So they need to be aware of what you're doing
Do we put that in
during the
secret
summer
document?
months.
Okay. Then I would
We'll
recommend.
put it in the construction contract.
Yeah,
We can also amend the secret document and include a fire
okay,
plan.
thank you.
We're not going to.
So, Gary, it looks like the recommendation is to conduct a public hearing and adopt resolution 2018-23. Is that
Correct, sir. I want to get back. I'd like to request that the board open public comment.
Director Weber,
Yeah.
Director Weber's question, have all her
Okay,
questions
sorry,
been answered?
I don't know what you're asking me.
I was just asking if all your questions have been
Yes,
addressed.
yes.
Oh, excellent,
Thank
thank you.
I'd like to open
Is there any public comment?
You don't open the public hearing.
Yeah, I'm going to open the public hearing. Is there any public comment? Any questions? Any more questions? No public comment?
So let's close the public hearing and we can consider.
Close the
resolution.
public hearing.
Close the public hearing. I would request that we adopt the resolution. Adopt the mitigating negative declaration and approve the project mitigation monitoring reporting plan for the resolution 2018-23 for Altamira tank, reservoir replacement tank, and amend it and include a fire plan as required as part of the contract.
What we can do is, at your direction, Director Weber, we can include that in the construction contracts, that's a required element of the project.
Right, and that it be filed with the fire districts locally.
So just to be clear, that we're not amending the resolution or the CEQA analysis before
I
you.
understand.
But it'll be a
It'll
required
be in the
component.
construction contract. Probably be more noticeable there than it would in the CEQA.
So moved.
Second?
Second. Any public
I'll just make one comment.
motion and second?
Oh, if I could just make one comment.
Go ahead.
I did attend the meeting in which nobody showed up.
And by nobody, he meant public.
I understand. I accept the fact that I'm nobody. I have to commend the consultants in this case. To me, a project of this sort, I think probably the significant long-term impacts would be aesthetic impacts. I would draw attention to Exhibit 3.1-5 and Exhibit 3.1-6, the simulated views of the tank. And thank you. Those are very instructive. I guess you can do computer magic and you can do those simulations. But those completely address my concerns.
I would have gone with a chartreuse.
Well,
Can't hide it featured.
Look at all that potential graffiti
Pick the
room.
color.
No, the simulations were very helpful. And that's, I think, in my view, probably the most significant long-term impact. There are, of course, many potential construction-related impacts, but those tend to be ephemeral.
Okay. Roll call, please.
Division 1.
Aye.
Division 2.
Aye.
Division 3.
Aye.
Division 5.
Aye.
Division 4.
Aye.
Thank you, Board.
Are you next? Combi sediment sale disposal. Review the Combi reservoir sediment and mercury removal project sediment sale and disposal. This is, looks like an informational item.
Are we going to eat?
Who's on? Who's on board? You on deck?
We ready?
Yes.
Okay.
Yes, sir.
Thank you.
You're welcome.
I'm Greg Jones, the Assistant General Manager. Hello, public and board and staff. I'm going to go through the soil test assessment and results that we have thus far at Combi Reservoir regarding our sediment and removal program that is actually underway as we speak. And we have a presentation, I think it's our last PowerPoint of the day, so I'll go through it as quick as we can so we don't fall asleep in the waning hours of the morning.
Be nice to Otis.
No, they're all awake at this point.
This report was helped put together by the Sierra Fund to help with this test. They unfortunately couldn't be here today to help present the findings on our report, but I'm going to go through and see what I can do to sort of adjust and amend what we can talk about here. So what we have out at Combi, the project title is the Combi Sediment and Mercury Removal Project. It's titled that way for a particular reason in that there are, throughout the 1880s, with the advent of gold into the area, mercury and elemental mercury was introduced in large quantities in excess of what is already sort of naturally occurring within the region. And now we have sediment that has been picking up the mercury over the years through stormwater runoff from the mountains and the hillsides and depositing itself into the sediment beds of reservoirs throughout California, I might add. This particular project, as we know, has been one to help augment and remove a lot of that mercury as much as we can and try to test how much we've removed from the sediment and the system in general and how it reflects upon the aquatic environment within the reservoir. So mercury is a really tricky animal. There are two... Oops.
That same picture right there?
Yeah, sorry.
Before and
tricky. The mercury is trickier than this.
Was that before and after?
No. No. That is just two different pictures.
That's low and high.
One is standing on top of the sediment, maybe a year or two ago in October, and the other is looking from a side angle of the sediment, and I'll talk about some of the depths here in a minute.
The green thing, you know.
Yeah.
That's just one
Yeah.
thing you're looking at.
Yeah, no, this is Combi.
No, I understand that.
So,
We dug it out of it.
so mercury and reservoirs in general, and the soil in general, there are a couple different ways that these are treated and regulated for, and regulations apportioned to. On the one hand, we have the water board, and our presentation this morning alluded to the fact that the water board is the regulatory agency that is involved with in protecting and ensuring that our water systems are healthy and void of harmful exposures from use. So that is regulated by the Clean Water Act. We've talked before about the permits that we have for this project, including the 401, the 404 from the Army Corps of Engineers, the NPDES, and waste discharge requirements. So those are our water quality regulatory concerns for this project. The other piece, and the purpose of this conversation today, is really the conversation about what is involved, what is inside the soil itself when it gets out of the reservoir. We know that when it isn't within the reservoir, and I'll allude to the slide here in a minute, mercury can do any number of convoluted moves, right? And you have to be quite the scientist to understand it. And part of this process is the USGS helping with understanding this scientific activity of any smallest molecule of mercury, elemental mercury, within a reservoir system that methylates throughout the bioaccumulation field. So we have mercury within an aquatic system that is embedded within sediment, and then we have mercury that is outside of the aquatic environment in a terrestrial environment that is embedded within sediment. So these are two separate things. All of the regulatory activities that are involved in both the sediment of terrestrial when it's sitting on terrestrial dry land and when it's sitting in water, all of these regulatory environments are designed to help prevent harmful exposures and regulating specific pathways and environmental receptors that would input into the human body and therefore cause harm. We know that there are pathways within the aquatic system of mercury to methylate and bioaccumulate in the water body. So we have, like we talked about before, we have adjusted our project to entail removal of the sediment within dry environments, as well as testing removal of sediment in wet environments, which we will do in the summer of next year. We will now be removing sediment in the dry of this year as the lake level drops, and it does every year around this time. Currently, today, the lake has dropped somewhere around 10 feet. We have folks out on the reservoir now that are assessing some of the soil content, and I'll talk about that in a minute. So the reason why we changed to also remove sediment in the dry was, one, to avoid any long-term environmental concerns within the aquatic system and stirring up any sediment and turbidity in the water, as well as economic review that we can just really remove more sediment in a dry environment than we can in the wet aquatic environment given a period of time. And we can do it for a lot cheaper. So what we have done in the last 2 falls, we have gone out and transect the project processing area. We roughly have 30 some odd boring samples that we have drilled down into the sediment, brought back up, and tested for all numbers of different metal constituents. And so we've done that in the 2016 and 2018, and currently we are conducting pre-excavation samples on smaller plots in advance of removing elements or removing the sediment this fall. So here's a cross-section of some of those sediments that we have bored. This is just a one area. I think there's about 11 borings on that slide that we have, and some of them are going down 20 feet, some 5 or 6 feet, but depending on where you were in the reservoir body. But as you can see, we've conducted cross-sectional analysis of the sediment over the whole area of the working environment, and now we are doing pre-excavation samplings as of Monday. We've been out there, and Jason Mura, project manager over with Holdridge and Cole, NV5, is here with us today, and he just came in from taking off his galoshes and suit to get in here in a tie, and I think we've run through how many pounds? 300 pounds, 3,000 pounds of, and we've collected roughly 60 plus samples. Is that about right? So in the last pre-excavation sample. What this means, pre-excavation, is that in advance of excavators and backhoes moving out onto the surface of the sediment, we are doing micro pre-excavation samples of each of those sections within the sediment boundary, and we're testing those for mercury content as well. If we find an area that has elevated mercury content, well, then that's going to be moved through the centrifuge machine, where we'll be extracting that mercury from the content itself. So we are sampling not only large depth boreholes, but we're also pre-sampling before we excavate in the dry this fall. So what does it really matter? You've seen this slide before. Mercury will bioaccumulate in the food chain. This is one of the main purposes of the project, and it is to educate and bring forth that as we trying to determine the process of removing mercury from the system, how much of an effect will that have on zooplankton and fish and sport fishing in general throughout the Lake Combi, but the Sierra in general. Let's see.
It looks like Verona, confluence of the Feather and the Sacramento.
that is a standard photograph of just of any old place. It doesn't have to necessarily. It's not. It is not Combi Reservoir, I don't believe.
So you're doing it in the Feather now.
Well, picture.
So we want to. So any small amount of mercury that is within a reservoir has the opportunity, given the right circumstances, to methylate and bioaccumulate within a food chain. There are, you have seen notices of fish warnings throughout reservoirs on Rollins and Combi. You also seen it throughout reservoirs throughout the Sierra Nevada and California in general. We have multiple advisories going on. Our partners at the Sierra Fund have been putting these out over a number of years, where we've been educating public on fish consumption and persons of high risk, children and the elderly, and folks with who are childbearing age. And so what these do are really help educate the folks and people out there that these reservoirs do have a water body concern, and that doesn't mean that we can't swim or recreate in these reservoirs. It just means that there are bioaccumulation of mercury throughout the fish, and it could bioaccumulate if we eat that into our systems. This is a very difficult table to read. However, it's kind of the meat of the conversation here. And what this table is telling us is that there are, remember I talked about the regulatory environment of sediment in the water, in the aquatic environment, which regulates our 401 and our 404 and our other regulatory concerns with fish and game. And then there is the regulatory body of the California Department of Toxic Substances Control and the U.S. EPA regional screening levels for soil when it is out of an aquatic system and into a terrestrial system. These numbers represent where we have found any level of elemental mercury within those 30-plus core bore samplings, and it is, and we are doing the same sampling on the smaller samples we're doing right now of, as Jason mentioned, the 3,000 pounds that we've removed within the area that we're excavating this fall. And so we're predetermining how much mercury might be within a element of that area. As you can see, there's a number of different constituents that we have assessed against: zinc, let's see, nickel, lead, copper, cobalt, chromium, barium. Starting from the right, and as you go over to the left, we've got methylmercury and mercury. On On the top line, we have the DTSC, which is the Department of Toxic Substance Control, and the RSL levels, which is the U.S. EPA's, regional screening levels for toxicity of sediment in a terrestrial environment. Up at the top is their ppm, so parts per million. You can see across the board. On all these, as we go from right to left, you can see, for instance, zinc at 27,000, 25,000, 23,000 ppms. We have an average of roughly 12.4. As you come over to nickel, that's a 1,600 or 1,000. Boy, my eyes are bad. 1,600 threshold level of toxicity. The nickel elements that are within the soil borings that we've done thus far are roughly 15. We're coming in quite low, which is really promising and helpful and good. As we get over to the mercury side, you can see that there's two. There's the MEHG and then there's the HG. MEHG is the methyl mercury, and that is a bioaccumulation of the mercury itself, of the elemental mercury. You can see that it is a 7.8 in the ppms in the soil criteria.
It would be the amount that's available for bioaccumulation.
The amount available for bioaccumulation, exactly.
That's correct.
Mostly in an aquatic environment, not in a terrestrial environment. You can see that our averages that we came out to be on the terrestrial were very, very low, but still, but detectable, but at a 0.000 level. The elemental mercury is what we really want to focus on, and that is a 1 parts per million threshold to toxicity. Our samplings, as you can see, we've averaged out in total of all of the 28 samplings of I can't remember how many pounds that was of core borings, but some went down as low as 25 feet, some as 5 feet. We have an average of less than 0.42 ppm, but that is averaging even the core boring samples that had less than 0.1. So really, that 0.42 is lower than 0.42 in terms of an average of all elemental mercury that we have found in the core samples on Combi Reservoir, indicating that as we move the samples, or as we move, the sediment from the aquatic environment to the terrestrial environment, we show that we indicate that this sediment, although has been discussed as a toxic element within this room and others, as we remove it from an aquatic environment to a terrestrial environment, we're showing that this sediment itself is actually quite inert at any level, and it can be used as fill or sediment that we plan to do with it moving forward. So some of the key points I wanted to just reiterate is regarding concentrations of mercury and methylmercury, they're regulated differently. We've got sediment regulatory, and then we've got regulations for water, the sediment, which is aquatic. We believed that removal of this sediment in the dry is both environmentally and economically better than a removal system in the wet, and we can actually get more out for less money. And that's why we made the adjustment to the project recently. Removal in wet, we will still go through with that this spring and summer with our suction cutter head dredge that will be out on the system, but it has this unique suction cutter head that is designed specifically to reduce turbidity and methylation of the mercury itself. Finally, this project, our partners and everyone on board, we are testing, we're monitoring, We're ensuring that we meet our regulatory compliance issues. We're monitoring efficiency and effectiveness of the system as we move forward. That, I think, is the end of my.
I've got a question
update.
over here.
Yes, sir.
Didn't I see in here that you were looking at a new disposal site?
Temporary disposal site, right?
Originally, we were just going to put it on the riverbank with a little 2-foot wall to protect it or some such. I was hoping, I was reading that we were actually looking at some other further away sites.
Yeah, what we're end up doing
I'm
is
not
that.
sure what was going on, that's why I'm asking the question. I just kind of read it and I thought there was a reference to it.
Yeah,
So
where
are we on that?
We're still going to be disposing of this product for a short term onto the Tykert's
With that
property
2 or
with a
4 foot
foot
yeah.
bank that's gonna
Protect it.
impede any, and we've got stormwater management plan, we've got best management practices, we got erosion control. However, in term, I think what we're going to find is we're going to either be selling this material off as we go forward, or we're going to be moving it ourselves out of the system into a place of future choosing. We would like to sell it. However,
You hadn't consolidated that secondary site.
We
It
do.
was alluded to, and I thought, oh, good.
it would be ideal to sell it right now.
Sure.
And get it and move it.
Weigh it while it's
Moving
wet.
it twice is more expensive than moving it once.
Weigh it when it's wet, come on.
That's right.
That's
But
the marketplace.
but what I think there's somewhat of a stigma is this this
degree of contamination.
That's correct.
Sure.
Whether it's in the aquatic or the terrestrial. So today was really just a conversation of the terrestrial.
Sorting that out.
Yes.
Okay, I appreciate you going into that. It sounded like there was more to that secondary site than maybe we haven't really done.
There was more than we anticipated to get it out, and so we're moving it short term with a lease with Tykert right now, and then we're going to move
Which
it out.
was the original discussion?
Yes.
Okay.
Nancy, you had a question on that?
Yeah. Does this report relate to the CEQA adjustments that I requested for storage of the materials? But it isn't the same as it would be within a CEQA document, because there would be mitigations.
We have all the mitigations. We have all the mitigations that we would have in the CEQA document as well. The CEQA document.
Mitigations for the storage?
Yes. For the storage, correct.
And what are they?
Stormwater protection plan. We've got sediment, our best management practices, our Jason, maybe you can. But those are what we have is we've got the storage of the sediment. Is that what you're referring to?
That was my request, was that we look at expanding the CEQA to include storage, because that was not in the original. It was in the original, but I don't know that. I don't have that information.
The original document talks about the we talk about all. So we had anticipated in the original project, Director Weber, that this material would be sold out of the system, right? That we would pull it out and it would be a needed material and we would sell it out of the system. Of the material that is unsellable, we would dispose of it according to state and regulatory processes, and that is what we're doing. We're making, we're putting this material into pile, and we're adjusting it with stormwater, with our stormwater plan that's going to be dewatering it into sediment ponds and moving that water out. And so we feel that material, as it's put into a sediment storage, is appropriate for all permitting and regulatory environments. And we've been in contact with Placer County around this, and have received we've received authorization from them.
So how do you account for fish advisories, where definitely there is mercury in the fish, and the fact that you found no indication of mercury in the sediment?
It's not that we haven't found indication of mercury in the sediment. Indeed, we have found indication of mercury.
Well,
it's just the two different regulatory environments. Sediment with mercury in an aquatic system, given the right environmental circumstances with temperature and oxygenation, even the smallest amount of mercury, elemental mercury, quicksilver, can methylate. And that's why 190 plus reservoirs in California are 303D listed, which we've talked about before. That is the bioaccumulation within the aquatic system. When that sediment is placed on the land, the dry land, you see the mercury content is well below Department of toxic substance control levels for toxic level sediment. That's the difference. It's not a matter of, it's the same sediment that's coming out from the water to the land. It's just that when it sits on land, it doesn't have the opportunity to bioaccumulate and methylate up through an aquatic food chain because it's sitting on the land.
Because it's dry land and
That's correct.
it's not aquatic.
Pretty much.
No, because it's aerobic as opposed to anaerobic.
That's one of the factors, yep.
And
Director Weber, I think I'd be happy to meet with you, and it seems like there's a disconnection, and we don't have the documents to point at and say, right here in the document, it says this, and maybe that would be better.
We're pretty visible on the state scene, so please do whatever we need to do to meet requirements. I think the storage of sediment with mercury in it is a little bit different than what might be under a permit. It's a bit unique.
So just to answer that real quick one more time, the permits are with the Water Board and Fish and Game. If we analyzed the sediment and it had elevated levels of mercury within it, then that then elevates it to a different system. But we're not finding that at all within the system, and we're continuously monitoring for it, even as of this week, on even smaller level
puddle of
scales.
it somewhere, because
And we
my
might, and that's-
understanding is that it tends to.
And if we find materials that are hot, Director Weber, we'll process it.
We run them through the centrifuge machine to extract that material, and then it's placed in the clean pile. If
Thank you.
as a
Thank you.
Is it?
any other questions?
Any questions for the public? You can come up to the microphone, identify yourself.
no. Mike Pasner in Eden Springs Farm, Penn Valley. On that chart we had up there earlier, there was a category. across
Farming with
the-
NID water for 32 years.
Thank you for reminding me. Yes, sir. Across the top of that chart was a category, soil regulatory criteria. It had numbers for both. It's had the names in the elemental table across the top. Mercury was one of them with an amount, and then copper was one of them with an amount 660 parts per billion. Is that
660 parts per million.
per million?
Yeah. You're off by a factor of 1,000, Mike.
that was cobalt.
CU, 300 parts per million.
And zinc, by the way, is not ZI.
CU. CU right next to CU. 300 parts per million.
What does that mean? Is that acceptable in soil?
That is the soil regulatory criteria. That's the threshold.
For copper.
The table shows 6.7 is our highest,
This is our average.
or 8.7 is the average, 6 points, because, yeah.
9.7,
So-
further down.
And that's, you want a copy of the, you can have mine.
I'll take a copy.
Okay.
Well, he justified them when he went through it, that they were, the dark ones at the top are the criteria based on,
Based on the Department of
EPA.
Toxic Substances, EPA, Cal EPA's threshold levels.
So for
and I presume you would have bolded any that were in excess.
But where Mike's headed is
None
why
of
is
these
this
were
number
bolded.
different than what was reported to the M&R as the TMDL? Yeah, TTLC. Why is it different?
What are we talking about?
That's the toxic level.
copper.
Of
That's
copper.
acceptable in the soil or what? That makes
Will
it
is
a,
done for the day.
That was the beginning of his discussion, was the top numbers. You were
Correct.
describing-
Yeah.
I don't know the answer.
We might have to get back to you on
Figure out
that
how
answer.
these two are connected.
There is
Reported out at
another
M&R.
there's another level, and we'll bring it to M&R and bring that back. Yep.
Okay.
We're still within those thresholds anyway.
Yeah, you're within the threshold.
Yeah, well, but how do we all of a sudden have 300 ppm and whatever?
Well, there's residential, and then there's commercial.
Right.
Well,
So-
we're gonna answer that.
George,
we're gonna
Jordan's
answer
raising his
that.
hand back here.
You can come up to the, you want to answer up here?
Raise your hand. Chime in, young man.
Yeah. You came all the way here.
You're
you
here
might as
as
well
our
say something.
authority.
Jason Muir, NV5. TTLC is total threshold limit concentration. That is the level at which, in California, material is deemed hazardous. And so for waste disposal purposes, it would have to go to a different type of landfill if you were disposing it as waste. And the numbers that we're talking about today with the DTSC screening level and the RSL, the regional screening level from US EPA, those are long-term exposure. It assumes that you're exposed to the material every day for 30 years in a residential exposure scenario where you incidentally ingest 200 grams per day, you are exposed to dermal contact every day, and that you inhale soil dust every day. And so in our field, the DTS CSLs and the RSLs are the lowest threshold that we can subject something to, the most conservative numbers that are out there. And exceeding those conservative numbers doesn't necessarily mean that it's hazardous. It doesn't mean necessarily that it's actually an exposure risk, but it means you might want to test it some more and see if it actually is a risk. So what we're talking about is the most conservative numbers that we use in California. And
Those are the bolds across the top of
that's
the-
correct.
Okay.
Yeah, and so we're subjecting it to the lowest numbers that we can, and they're below it.
So we're still.
Those were expressed in parts per million, yeah.
So you're basically saying that 300 is the lowest concentration that is considered any type of risk?
Yeah, it's typically related to 1 per million lifetime excess cancer incidents over 70 years.
Sure.
And a hazard quotient for a 30-year exposure.
And the copper levels in these sediments are orders of magnitude below that.
That's correct, yeah.
Just as we found in the canals.
Yeah.
Okay, thank you. One more question.
Yeah.
You got a short one? You state your name.
Mikos Faberson, resident of Nevada City. It's related to the previous discussion on the chart that was put up. So for elemental mercury, the threshold limit was 1 part per million. I believe from looking at all the core samples, you had 0.63 parts per million was the highest that you saw. It would seem to me if I were a resident living in that area, since the sediments would be brought up, put on the land and dried, that there is some possibility of dust creation and maybe sitting there from winds picking up any of this soil. Has there been any plan to do any dust control so to prevent any of the contaminated soil from reaching nearby residents?
Jason Muir again, NV5. We do have a dust mitigation plan. We have a stockpile plan, and we have best management practices for controlling wind erosion as well as water erosion. This material, in that sense, from a dust exposure standpoint, doesn't qualify as quote contaminated material because it's below those conservative thresholds. But we are doing dust control.
Okay, thank you. All right. Thank you. Let's move on. Item 6, Maven Canal Emergency Bypass.
Good afternoon, board, public, and staff. My name is Gary King, Engineer Manager for District. This is item number 6. Maven Canal Emergency Bypass. It's part of the Maven 2 encasement project, FATAR number 8099. The intent of this is approve a change order to Hanson Brothers for the Maven 2 Canal project in the amount of $192,258 and approve a budget amendment request in an amount of $90,759.33 and authorize the general manager to execute the necessary documents. Recently, staff had to go out and do an emergency repair on a siphon on the future Phase 3 of the Maven Canal. That piece of pipe that they removed is that special piece of pipe over there. Just to kind of give you insight, it's pretty well rotted out. It was leaking. They were able to limp it back into service.
Placed when?
Okay, good question. I got that. It was This was placed in about the Maven Canal was built in about 1938. We anticipate that this piece of pipe was put in the 1950s.
Wow.
Okay. As you can see, the one special thing about that piece of pipe, and I'm going to try to be short about it, it was not a design joint. They just jammed two pieces of pipe in, dented the interior one and dented out the other one, and they jammed it together and sealed it up with clay. So yeah, the intent of this project is to replace that section of pipe. And I don't think I need to go any farther. That needs to be replaced. Going into budget, $101,498 comes out of the raw water repairs program, 101-515-20910, with the remaining balance of $0 for the rest of the year. $90,759.33 will come out of minor system work, budget number 101-515-2909, leaving a balance of $177,680. That's our budget. It is recommendation of staff to approve this change order so we can do this emergency repair. I've shown a map with the location. It's on the future Phase 3 project, so this will assist the future Phase 3 project. But at this time, it's staff's recommendation to replace this as part of, since we have a contractor in the area and we're ready to go, and the condition of it is questionable.
Gary, could you please explain I've been trying to wrap my head around this last paragraph. And it's Hanson Brothers about the low bidder. How did this turn into $192,000?
It's not part of the original work. This is actually another piece of, it's downstream of the work we're working on right now. And because of this issue coming up, we're change ordering the current contractor in the area. The intent of this is to inform the public that we are actually using the Hanson's original bid as a low bid, multiple bid. It was bid multiple ways, the original Phase 2 project.
Jeez.
Okay.
So Phase 2 is upstream, Will.
Yeah.
We have a mobilized contractor, and we have an asset nearby that is in fail. So we're just asking to bring that contractor onto this work and save ourselves the mobilization cost.
Right. So my understanding is this actually, if you step back and look at the big picture, this saves the district a significant amount of money.
Yeah.
This is pipe that will be replaced anyway next year.
Correct.
Under a different contract, in which case you would have to pay the mobilization all over again next year. And so we're doing this work now in lieu of doing it next year. And so overall, this is a saving.
I think given the state of the pipe, Nick, you're avoiding not just a remobilization under contract, you're avoiding a 3 times expense of mobilizing maintenance
for failure.
For emergency repair.
This seems like a no-brainer to me.
No, it seems logical, but it just didn't seem to
read right.
I guess
didn't get the right numbers. It didn't seem to compute.
What we're trying to do is make it clear to the public and the board that all we're tying into is already a bid project. It's been bid. It's been through the process. We have a low bidder. We compared the low bidder's numbers to the change order numbers, and they matched actually a little lower. So what we're trying to make sure that we are giving understanding that we are this is a fair and reasonable cost to the ratepayers of the district.
So the mobilization cost would have been how much?
Probably typically about $10K for just to do this one job, because you have the low boys coming in. The equipment's just going to march down the road a little ways and go do the job.
I understand all that.
Yeah,
I get it now. I just was having a hard time with it. Any other questions? Public comment? Okay. Got it. Your motion?
Sure, I'll be happy to make a motion. I motion that we approve the change order to the original contract with Hanson Brothers in the amount of $192,258 and approve budget amendment.
And authorize general manager to.
And authorize general manager to sign the documents.
Second.
No public comment? Okay. Motion and second. Roll call.
Division 1.
Aye.
Division 3.
Aye.
Division 5.
Aye.
Division 4.
Aye.
Thank you,
passed.
Board.
Item 7, annexation, Upper Ridgeway, Placer County.
Good afternoon, Board. Greg Jones, Assistant General Manager. Today I'm bringing before you the recommendation to adopt Resolution 2018-24, making an application for annexation of land in an unincorporated area of Placer County to Nevada Irrigation District and authorize the General Manager to execute the necessary documents as recommended by the WHO Water and Hydroelectric Committee. So as a bit background, on January 19th, 2007, LAFCO adopted resolution number 0701, which adopted our sphere of influence, our 2006 update.
Is there a better map?
I think it's in your area.
Better
That's what I
map?
was trying to figure out. I think I can read Lone Star.
I did not put
There's another
the
one,
I
Scott.
did not put the districts in. I apologize for that.
That's even too small.
Yeah, I didn't put where the district boundary is. I'm
Yeah, it
sorry.
was these
I
guys.
apologize about that.
And I
That
was
should
trying
have
to-
that should have happened. I believe it is within your district.
Here's why I was curious.
Yep.
So I am seeing Lone Star,
Yep.
Yeah.
and then it was,
No window today.
we needed one in between that would kind of give
Yeah.
some roads.
A line. Sorry about that.
That's all right.
Um,
Spent some time looking at it.
The purpose of that update was to
So was this in nobody's water district then? Is this an island?
This is an island.
exclusion?
This is an island. This is an island exclusion, and NID has had a moratorium on islands until we recently passed the 2017 tax sharing agreement with Placer County.
Okay.
So this
And
is the
then we're
first.
only doing a portion of the island in this particular case.
That is correct.
And is that Camp Far West right there?
Yes.
And that would be Combi?
Yes.
I really was trying to get this map in. That's the Bear River.
No, that's Lake of the Pines.
Oh, LOP, yeah. I'm
Yeah,
sorry.
that's Lake of the
LOP,
Pines.
But that is Camp Far West.
Yeah.
And so these folks.
The golf
so
course.
Where's Auburn?
Golf
yeah.
course is right above it. The Auburn Valley is right. There's the island right above it.
Oh, that's the,
Yes.
not the big swamp,
No.
but the little swamp.
Yes.
Huh, interesting.
I can get for you if you'd like
No, I appreciate
additional
it. We've done it
information.
now. I just, that's all I
Okay.
needed to kind of.
Okay.
I couldn't quite get it there.
Okay. So since
There's no water there.
since 2011 or 2000,
Wells are filled.
we have had a moratorium on additional annexations to the district until we set this tax sharing agreement, which we completed on February 2017. This is the first piece of annexation that private property owner has come to us and said, hey, we are interested in
That's how it happened.
becoming part of the district.
And is
This
it single owner then?
No, there's 11 parcels.
Okay.
There's 11 parcels in this block. What happens is Placer and Nevada County LAFCO, when they look at an annexation, they look at a relative, not just a single unit, because there's enough work that goes into it that we try to incorporate as many sort of as many parcels around it that makes sense, right? From a chunk perspective, I guess. And this chunk kind of hangs off that larger chunk. If that's a term.
That's technical LAFCO.
Right, technical LAFCO term. So this is roughly 235 acres on 11 parcels. We have received a consent signatories from each of those 11 property owners in moving this forward. Now, NID will not be extending services to these parcels. As you can see from, I think it would be this map that folds out, the Rudd and the Lone Star canals end along that road, which I don't have the name of that road off the top of my head. That's that road just to the east. Yeah, the north-south road.
Brewer?
Bell.
I mean Bell?
Is that Bell?
Yeah.
Okay.
It actually swings around and starts going.
There you go. So we do have canals that end there. It would be up to the individual private property owners once annexed in to then to then extend water from the canal to their homes.
They put a service box on and then
That is
pipe it
correct. That is
with
correct.
Their own easements.
With their own easements through the other parcels, with their own feasibility, with their own costs. That is
And
not,
we have a moratorium on mutuals,
that is correct.
so they would have to each individually or somehow figure it out. We don't do the mutual thing.
Correct.
This would be one of those situations where they probably want to be a mutual.
They probably,
Community pipeline.
they probably would work on something like that, and the engineering would work with them when we get to there, as well as the water ops. So it is up to the private entities to determine the timing of when they want to bring those services over. All this is, what I'm asking today is to bring the resolution of application to submit with the application to Placer LAFCO that says that our board has resolved to make this application happen. There is a series of costs associated with moving an annexation parcel such as this towards the LAFCO process, and you can see the breakdown here. It's roughly $16,000. We have that budgeted currently in 2018's budget account 10115, account number 52603, which would really, with subtracting out the $16,000, it would leave a remaining balance of roughly $33,000 left in that account. Once the annexation is approved, then at that point, due to the Placer County tax sharing agreement, NID would start receiving a proportionate share of their existing tax base. Tax base for these property owners do not increase because of this action.
And I don't see Chip here, but we've had overflow stormwater issues in this very same area. So is there capacity for these people to be able to tap in? I mean,
yes.
No moratoriums in that part of the...
No.
This overflow's always just been stormwater.
What?
Near there on some of these roads, right, going in there, you know what I'm talking about, yeah. There've been some overflows, somebody's culvert, whose culvert, blah, blah, blah. It's the same neighborhood.
Yeah.
Yeah.
Kramer Road.
Kramer Road.
Okay.
So the capacity for them.
Stormwater
Okay.
Stormwater overflow is different than
I
capacity in the
understand.
ditch.
It suggests that we don't have deep canals there or something. I mean, I understand. I'm not trying to conclude. But there is actual capacity. There's been no moratoriums in this part.
That is correct.
It's just we didn't have service requests.
Correct.
Okay.
Okay. I move that we adopt Resolution 2018-24, making application for annexation in the unincorporated area of Placer County to NID, and authorize general manager to execute the necessary documents. Thank you.
Any question?
Second.
Got a motion and second? Sorry.
Yeah, I do have a question. What's the name of the budgeted account for this?
The name. I wrote down the number.
I can't relate that number to it.
603 is consulting, is contracts and consulting.
Consultant.
The last three digits.
Yeah.
603.
So the 52603.
Okay. For a time, people requesting annexation needed to pay the LAFCO fees, and I think we abolished that.
Yes, ma'am.
Right.
This is not just a special agreement with Placer County.
No, ma'am.
Okay, thank you.
Now, those fees are still going to be paid.
Yeah.
Motion and second?
And those fees will eventually be recovered through property tax revenues.
That is correct.
And if these people decide to become customers, we also gain an advantage from that.
That's correct.
Can I just briefly ask, can I just briefly ask why that practice was, because it's before my time.
Because, I mean, I know why.
Okay.
Because people just weren't annexing.
Okay.
It was too costly.
Okay.
And we were sort of shooting ourselves in the foot by not picking up those costs. That's my remembrance of it.
Okay, that's perfect. We have 50,000. We've been carrying 50,000 in this account just for this action since I got here. And this is the fact that we're now have the tax sharing agreement. We can start doing it again. It's good to know. Okay, perfect.
And we have a few more.
Yeah, we've got 13. We've got 13 other folks.
We've got more than that. We've got a number of that are coming to us now and talking.
That's great.
Yeah.
Everywhere.
That's good.
Placer mostly.
Mostly this Placer area.
There's a couple in Nevada County. But yeah.
Okay, thank
Okay,
you.
any public comment? We have a motion and second. Roll call.
Division 1.
Aye.
Division 3.
Aye.
Division 5,
Aye.
Division 4.
Aye. Warrants, any? I don't know if somebody's calling.
You're vibrating again, Will.
I'll put this over here. Anybody have any question about the warrants?
No.
No? Any questions about the warrants? Public comment about the warrants? Okay.
I move the warrants.
Second?
I had a question for Marvin on the warrant.
Well, you're gonna have to wait till he gets back
Vacation.
from vacation.
Was Director Miller my second?
Sure.
Oh, thank you. Thought I heard a second.
Roll call, please.
Division 1.
Aye.
Division 3.
Aye.
Division 5.
Aye.
Division 4.
Aye. Okay, general manager's report. Here we are.
Yeah, you're the general manager. Check your name tag.
It's been a long day.
Check your name tag.
Good afternoon, board, public and staff. It's my pleasure to update you on the current situation of the district with regard to water supply. We are currently sitting at 185,075 acre feet, which is about 69% of capacity and 113% of average. So we're coming in a little bit higher than normal, which is if you looked at the audit, you'll see that we're the last year, 2 years, we've been doing quite well in terms of storage and runoff from our upper division.
Seasonal carryover, we want to be
Seasonal
140?
Our normal is 120 to 140.
120, 140, and we're 165.
Yeah, our normal, our actionable level 78.
Okay. So we'd like to be 140, and we're above that.
Yeah. Our August 2018 total treated conservation is at 13% over August of 2013, so also doing quite well. I'd like to take a moment to extend a big thank you and congratulations to Byron Bethany Irrigation District on the governor's signature on AB 747. This creates an administrative hearings office at the State Water Resources Control Board, so that they will hear and adjudicate water rights. So everything that we did this morning, now instead of the water board being judge, jury, and executioner, there's an extra body inside to help us protect our rights as we move forward.
Does that mean they're hiring administrative law judges?
It's just said lawyers. I don't know whether they're going to hire judges or just have. Are you going to go back to school? Yeah.
No, thank you.
Okay. Also, interestingly enough, Representative Durham and Representative Costa are advancing the American Water Infrastructure Act 2018, also known as SB 2800, that has a series of blocks of money for different storage projects in the state of California. Most focused, I think, at this point on sites, Temperance and San Luis, but they're moving this legislation forward for the Central Valley, which is interesting to watch. Prop 3, the Water Supply and Water Quality Act, currently at $8.8 billion. There are a number of grant opportunities inside of that I think NID will be able to go after and be very successful. So a lot of things moving right now that we're trying to keep our eye on. I had the pleasure of presenting to
and the water tax failed. Or
the water tax they pulled it. Yeah. So
it was a faux complete there.
Yeah. So they made a run. They didn't think they were going to make it, so they backed away without having a defeat. De Leon.
Without prejudice. So
yeah. No, it's Rendon. Rendon was the one that was saying we'll be back. So they'll be back.
Okay. At least for another year.
Whether it comes as a tax or a whatever.
I thought that was just big that it dropped.
Had the pleasure of presenting to the Ag Commission with Director Warbeck the other night, the raw water master plan as it stands now and where we're headed. We had our City of Lincoln NID 2x2 last week. That was interesting. We're not completely aligned yet, I think, but we have opportunities there. Also, had the pleasure of meeting with the Nevada Union Ag Advisory Committee to talk about internships and their CTE program, their career tech program, and how to bring interns into the district and how we're going to do that. And I'm very excited about that. We're creating, Chris and Jana are working on a way to create internships for two 18-year-old students, because we can bring them on without all the liabilities and not in violation of federal law. But it sounds like internal to the school district that they have a way to let students under 18 come on board and to deal with the liability issues and the laws around them. So we're really excited about that. We're also working with the fairgrounds at this point. I don't know whether you know, but during the fair, a transformer exploded on my circuit, but the fair went dark, completely dark. They have no generation anywhere, and with our 300 kW unit now in place, our little 30 kW unit isn't necessary and will be surplused off of our property. We don't have any other facilities that can use a unit that small. So we're working with the fairgrounds to see if there's anywhere that they can use this unit either to power the headquarters building or to power one of the other ancillary buildings to protect it during a power failure. So
actually, I was there that night. The Funway remained open. It was the demolition derby and Treat Street that
the
went
Funway
dark.
had a giant generator running.
Yeah.
Right. So
there you go.
It seems like
It
an
wasn't
opportunity for us
completely dark. It was
to
just suddenly
share.
dark, and so much for music.
Yeah.
Friday night.
Maven Phase 2 construction is still ongoing, and thank you very much for extending that work onto the siphon. Rattlesnake Road project final punch list is being generated. We should have, and the system is in operational, so we've taken substantial control. The control station for Alta Sierra to LOP is about to go out for bid. So this will be down by the Lions Lodge, right? Yep. Okay, perfect. Iron Horse DFWLE has enough participants, and we're still moving forward. I'm sorry, I'm laughing. It's been a long road for them. And it's been a lot of work. Hemp Hill TAC meeting on October the 23rd, so that's our meeting with the regulators and with the local project proponents. Phase 2 and Phase 3 of the main building expansion, we're looking to go bid in the next couple weeks. We're completing the cleaning of Loma Rica Reservoir for the year. We've done a great job out there. Signed contracts to evaluate Scotts Flat Recreation Office. That is a temporary building that we've inhabited for a very long time. And then at the November Engineering Committee meeting, we will be discussing LOP to Smartsville routing studies.
LOP?
LOP, I'm sorry, Lake Wildwood.
Say it, big jump.
Yeah, I'm going a long way. No, I think with Prop 3 coming, with some of the disadvantaged money that's out there right now, it really makes sense for us to continue to look at how to potentially bring Smartsville under wing and to connect it to some of our, to regionalize that facility. We're paying 150 to 200,000 annually to keep that plant operational for 44 connections, and so it continually has water quality problems because it draws off 2 canals that run over hill and dale through cattle pastures and whatnot. We've been working on that for a long time, but it's definitely something to put into our thought lexicon and to prepare the capital program for. So with that, thank you very much.
Okay. Board of Directors items, reports.
I don't have anything.
I'm always last.
No, I am.
That's true.
That's true. That's true. You saved the best for last. I just saw that.
Well, then I'm not even last. Damn. No, I have nothing.
I'm fine.
Do you have something?
I'd like to thank Nick for setting up the workshop.
Yeah, me too.
It was very informative.
Well, thank you for your patience in sitting through it. It's a complicated subject.
Complicated to be sure.
Okay, I just have 2 items. I concur. I went to the Lincoln 2x2. I concur with what Rem had said about the meeting. It was interesting. So that's what I can say. But there was some positive elements to it. Also, I attended the Ag Commission meeting last Monday, and I sort of tag team along with what Rem had talked about with the raw water master plan. I think that the Ag Commission, and there's also Ag Commission here in Nevada County, are well suited to fit right into the ag element of the committees that are formed, because I think Nevada County is like Placer County in that they each represent a different commodity. So I think it would give a good cross-section of the commodities if actually the whole commission would join in. And anyway, I was encouraging them to do that. And so I think that's all I had. I went somewhere else. I went to the Fruitvale School last night and spoke with them. And that's about it. So I think is there any public comment on items to be considered in closed session? No? Okay, we stand adjourned. Thank you for hanging in there. It looks like one of my last concerts. I'd like to close closed and open open, and I'm going to defer to Mr. Cooper.
Okay, thank you, Mr. President. It is 2:50. We are out of closed session. The announcement as to the first item, the claim of Ashby Lane in Newcastle. A motion was made by Director Wilcox, seconded by President Morbeck, and unanimously carried with Director Drew absent to reject the claim of Ashby Lane in Newcastle. Concerning conference with real property negotiators, direction was given to the district's negotiators. And lastly, concerning the pending and potential litigation item pertaining to the proposed Centennial Water Supply Project, direction was given to legal counsel.
Close